Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near and give their witness, and they shall be heard.
Good morning, thank you. Please be seated. The first case on for argument today is People v. Williams. Waiting for Mr. Lewis to join us.
Judge, it looks like we have him. It's just taking a little bit of extra time.
It's okay, we can be patient.
Can anyone hear me?
Yes, is this Mr. Lewis?
Yes, it is. I'm
Mr.
sorry,
Lew-
I'm getting a big echo here. The sound
Yeah,
isn't great.
we're getting a little bit of an echo here also. You're also not appearing by video. You're only, we're only hearing you.
Okay.
You're popping in now. There you go.
Popping in now. Okay. Is the sound all right or?
It sounds better now, I think.
Okay. Okay.
All right, very good. Mr. Lewis,
Thank you. Thank
Please-
you, Your Honor. May it
please-
please the court.
please proceed. Yep.
My name is John Lewis, and I represent the appellant Shalal Williams. The trial court was clearly in error when it refused to allow the defense to read before the jury the exculpatory testimony of Sharif Williams, no relation, from a previous CPL 440 hearing, after Sharif refused to testify at trial on Fifth Amendment grounds. The argument is pretty simple. Well, the court was wrong in three ways. The first is that the court found it couldn't come in as a declaration of against interest because the court found the testimony wasn't sufficiently credible.
Why don't we focus on that item? The court, as you point out, the court, there's four elements to that, right? And the court found the first three elements were met, but what struggled with the fourth element. What do you? Let's hit that one and explain to me why you think the fourth element was satisfied.
Well, because this court, which is the superior court on the previous appeal, had already found it implicitly reasonably credible because it would not have granted a second trial if it would have found harmless error on ineffective assistance of counsel if it had found that Sharif's testimony to be not credible as a matter of law. This is essentially implicitly law of the case.
Well, let's go past that, and let's talk about the idea that the fourth element, it doesn't focus on credibility, and there was an issue about the credibility determination by the court below. But what we need to find is sufficient competent evidence independent of the declaration to assure its trustworthiness and reliability, right? That's really what we're looking for. And I don't think the standard's high here. But what do we have? What competent evidence independent of the declaration would assure trustworthiness and reliability?
Well, number one, at the trial, Detective Kilbourne, who was really the main witness against defendant, it did acknowledge that he had heard, in days after the murder, he had heard what he called word on the street, that the murders were committed by Delvon Harley and Sharif Williams. Sharif is the witness, Delvon is the one who actually did do the murder.
And Sharif's the witness that we're dealing with here, right?
Yeah.
Yeah, okay.
And he says those were the two people that were there. Detective Kilborn acknowledged that word on the street is they were there. As a matter of fact, one person, a man named Shokeem Kelly, came in and told Detective Kilborn that that Delvon Harley admitted to him that he'd done the murder. He was very scared. He said, "I shot this guy," and yet Detective Kilborn never even bothered to interview Delvon Harley or Sharif. I think that's some pretty good independent evidence. Secondly, of course, is the independent evidence is the very fact that in a declaration against interest, Sharif was putting himself in jeopardy. Now,
Well, let me just say this. He did in a way technically, but he distanced himself as much as possible. He said that Delvon's the one who committed the shooting unexpectedly, that your client, or that Mr. Sharif Williams was, Sharif said that he was there, but Delvon panicked and just shot into a window. It's a little different than Sharif saying, "I shot into the window."
no, but he's putting himself. I'm sorry, Judge. I didn't mean to interrupt.
Yeah, no, but I understand that there is the possibility of felony murder. There's a prospect of it, but I'm more concerned with the story told by Sharif. There seems to be some problems with it, some holes in it. It contradicts, it's not consistent with the testimony of the two independent witnesses here. One was Miss Long, who lived next door, and then it was the man across the street, Mr. Schultz. Schultz says he hears banging at the door. If that's true, and he has no reason to lie about that, that's not consistent with Sharif's statement. Sharif's statements, they went, we just right around back, didn't go to the front door. Miss Long testifies she hears one of the two men say, "Why did you shoot the woman?" Well, of course, Sharif would be in no position to know who got shot, if anybody, inside the house, let alone if it was a woman or a man. Those two, and I'm not saying that it necessarily means that your client, that Sharif is incredible as a matter of law, but those are concerns that I had. His testimony doesn't match, doesn't stack up with those two independent witnesses who have no reason to lie about this.
I'd like to speak about Timothy Schultz. And this would be page 19 and 20 of my brief. And on page 20, Schultz admitted, first of all, that he admitted he lied several times to the police.
Yes, he had a rational explanation, though. He lied about the severity. He wanted the police to get there sooner out of concern. Sometimes the police delay. He had a rational explanation for that. There's no explanation for why he would lie about the banging at the door. And no indication that he did lie about that.
I don't see why he admits he lies and he gets credit for being credible and Sharif doesn't. That doesn't seem fair to me. I don't know if there's a rational explanation. Maybe he's a good liar, but he said several things that were contradicted. He said that he heard, even though music was playing and he's all the way across the street, he says he heard somebody say, "I'll be back." But Christina Williams, who was right there at that open door across the street, said no, that wasn't said. He was contradicted in many ways.
How about Ms. Long? How would you challenge her statement about hearing somebody say, "Why did you shoot the woman"?
Well, somebody did say that. That
Right.
was Sharif Williams.
How would Sharif be in a position to know he's outside, he's not the one who committed the shooting? How would he know who got shot inside, let alone the gender?
Sharif knows what he said. Oh, knows the gender?
Yeah.
But
Because it must have been Sharif, if Long's telling the truth, it must have been Sharif who said to Delvon, "Why did you shoot the woman?" How would Sharif have any idea if anyone got shot, let alone gender, inside the house?
I don't know. I actually don't remember Sharif actually saying that. I'll have to take your word for it. But
No, Miss Long said that. Miss Long testified that that's what she heard from the
Ms.
two
Long
men.
also testified that in court at a previous hearing that she saw people. She was the one who saw things from her back porch, I believe, and asked if at the first trial to identify if Shalal Williams, if defendant was the person she saw, and she said no, he's not the person I saw. That's also Matika Long.
No. Well, the standard is, I agree with the presiding justice that the best thing you have going for you is that it seems to be a relatively low standard the Court of Appeals has set here. The question is there a reasonable possibility that Sharif's statements, his testimony, might be true? That sounds like less than probable cause. If it were probable or not, I would say it's not probable that he's telling the truth. But it seems like the standard might be less than probable, which works in your favor.
And again, this court on the last appeal knew all of this. In fact, in the people's brief on the last appeal, they argued the credibility issue. And this court, after due consideration, this very court found him sufficiently credible. Otherwise...
No, wait a minute. I wasn't on the last case, so I read very carefully every word of that, because I was wondering that. There was not a word about this court saying they found the testimony credible. They said it wasn't incredible as a matter of law based on his prior record, Sharif's record, but it didn't take a position, nor did Judge Dougherty in the underlying decision. Judge Dougherty did not say, I don't believe Sharif Williams. He said that the lawyer was not ineffective. Your client's lawyer was not ineffective because all these other good things he did.
Right. But I'll tell you what this court, will quote from the last opinion, what this court did say was, and now I'm reading, moreover, the witness's testimony at the CPL Article 440 hearing was wholly consistent with the theory pursued by trial counsel, namely that defendant was not present at the shooting and that the crime was instead committed by an individual seeking to rob the victim's residence, and the proposed witness would have provided the only eyewitness testimony at trial as to the shooting. This court,
It's true.
it did write this about credibility.
Well, it said it was wholly consistent, but I get where you said initially implicitly, somebody could read that as an implicit statement that the panel found this testimony to be believable or credible or colorable. So I think that's more accurate to say implicit. But in any event, I interrupted your argument. You may go forward.
But the last thing I'll say about that, and I'll move on to two other things, is that my position is the trial court had no right to make that finding on credibility, given what was written in given the holding of the Second Apartment appeal. I implore your honors to ask yourself, if there was a real question about credibility, would this court have ordered a new trial? I think the answer is no. So that's the last thing I'll say on credibility, unless there are more questions on credibility.
No, go ahead. Next point.
Okay. The court also said that, and the people have argued that the ADA at the cross-examining Sharif at the 440 hearing didn't have a full and fair opportunity to do a full cross-examination, not as much as she would have done if she was cross-examining a trial. But that doesn't make any sense. First of all, by the way, that was Melinda McGonigal, one of the most respected and experienced ADAs, now a county court judge. She did not ask one question that there was not one question where the court said that's beyond the scope of this hearing. She was free to ask everything she wanted. She did get into the underlying facts and tried to show inconsistencies with Sharif, inconsistent with things that were known about the evidence. She did it many different ways. It was about a 24-page cross-examination, but she could have gone on forever. Not one question was objected to, and the court did not strike anything. And then, as a matter of fact, her mission on that 440 was exactly the same as it would have been at a trial, which was to show it was her job at the 440 to show that trial counsel was not ineffective for failing to even investigate Sharif, because to show that she was wise rather than effective, not to put on because he was so incredible. So the way to do that was to attack his credibility in every way she could. She tried her best. She's a very, very good attorney. And the main legal aspect is she had to have sufficient opportunity, which is People versus Robinson, 89 New York 2nd, 648. Nobody stopped her opportunities. It's not on defendant. It's not our fault that she quit when she quit in terms of her cross-examination. So I think the people's opportunity that she didn't ask, the trial court took it on itself to to think of questions she didn't ask. But, you know, that's on her. That's not on defendant.
Counsel, your time is
Okay.
fast approaching, if not already up. Would you wrap up?
Yes. And the final thing was the court said that CPL 67010 doesn't specifically allow for, it doesn't name 440 hearings as prior testimony that comes in. It only names prior testimony at a trial or at a felony hearing. But People di Tommaso makes clear that anything can come in. 670.10 doesn't bar anything that can come in if it's otherwise independently inadmissible under a recognized exception to the hearsay rule. In this case, it comes in as a declaration against interest, which is a recognized exception to the hearsay.
And we've already covered that argument, right?
Right, and we've already covered that, but it's 67010, and
Yep.
one case, a Fourth Department case, People versus Gardner, allowed grand jury testimony to come in, and that's not specified under 670.10. So Di Tommaso is absolutely correct. It's never been questioned, overruled. It's never been criticized in any way. That was a 2015 case.
Very good. Okay, thank you, counsel.
I appreciate it. Thanks, Judge.
Morning, Your Honors. Brad Oster for the People. I guess I can kind of go in reverse order. I don't think 67010 applies to this, to the type of testimony in question here. But certainly a declaration against penal interest as a standalone hearsay exception could. But with respect to the fourth prong, I think the record is essentially entirely devoid of anything that would in any way substantiate or corroborate Sheriff Williams' testimony. In fact, I think the record essentially just contradicts a lot of the claims that he has. And I know Justice Lindley talked about some of the physical aspects of his testimony that I think are contradicted.
Could you directly address Justice Lindley's point that the Court of Appeals has basically said that it's a low standard, lower than probable cause, and how that is reflected in testimony offered by Mr. Sharif?
Sure. I think you still have the standard set out by the Court of Appeals that is I think still readily applies, which is there just has to be some measure of evidence that makes the testimony in question trustworthy and reliable. And I would agree that's sort of a low bar in some regards, but what evidence here actually even meets that? I mean, it could be the bar could be as low as this court thinks that the language dictates. There's just nothing that substantiates his testimony really to any degree.
Well, I would say the only reason it's plausible to me in the first place is that Sharif obviously committed a home invasion not far from the subject residence that early morning, during the early morning hours, same time generally. He's been known to rob people.
Mm-hmm.
He's been known to rob drug dealers, violent guy. He was on a crime spree that night. So that puts it in the zone of reasonableness to begin with.
Yes, I wouldn't contest that. It was, fortunately an unusually busy night, I think, for the Syracuse police that particular evening. How
would you address Mr. Lewis's argument, which was my same thought, frankly, was our last decision, we reversed and granted Mr. Williams a new trial based on ineffective assistance of counsel. The ineffectiveness was not failure to call Sharif, but failure to interview him. And at that point, the panel in June of 2022, when they reversed, they had the benefit of Sharif's 440 testimony, correct?
Yes.
So why would the panel have reversed unless the panel found that testimony to be somewhat plausible, credible?
I think I can answer that in two ways, I think. Number one would be that to the extent that the decision can be interpreted as an implicit credibility finding, the inquiry, as you just said, Judge, was defense counsel essentially justified in just failing to interview him at all, failing to investigate to even somewhat of a low degree. And that's a different question than, is Sheriff Williams credible? Is it viable to call him at a trial?
We wrote a decision recently case that I was on that dealt with this. The claim was ineffective for failure to investigate or interview a potential witness. And we said that's ineffective only if the potential witness has credible testimony to give. In other words, if Sharif's testimony was categorically disproved by other evidence and it was absurd, this panel would not have reversed for failure to interview him.
Sure.
Failure to interview it assumes that the witness to be interviewed has something legitimate to offer.
Sure. And sort of the second half of my answer to this would be if this court's holding in sending this back for a new trial is read as almost effectively a mandate, you must call this witness. I mean, that would be somewhat irrational, because I suppose a defense attorney could go in and speak to this witness that they had neglected to do and find that there were other flaws or whatever takeaway you might have from the meeting, and find that this particular witness is either not credible or it's not going to comport with the rest of the trial strategy. There could be other reasons why an attorney might not decide to call a particular witness. I don't think, even if we again see the decision as saying there is some level of credibility to Mr. Williams' testimony, Sheriff Williams' testimony, it can't be the same as a mandate that this person be called or that their prior testimony be let in, because there's too many other considerations that can take place at a trial. And looking at his testimony even at the 440 hearing, this is a man who wouldn't acknowledge his nickname that defendant referred to him by. I mean, just something basic like that has no import on criminal liability or anything of that nature. There's serious flaws. There's red flags, I suppose, if I'm a person trying to judge his credibility on whether to call him or not, or whether.
That's kind of a difficult standard, though. I mean, in almost all cases, you get witnesses on the stand who have given maybe depositions or affidavits, right? And a lot of people's experience, when you're taking a deposition or you're having somebody sign an affidavit in a law office, it's much different than the witness sitting on the stand in front of a jury and then being examined and then confronted with their affidavit. The idea that if there's inconsistencies found between a prior affidavit or deposition and what's being testified to at a 440 hearing, for example, and because there's inconsistencies, this becomes unreliable and not credible as a matter of law. That would be a very hard thing. You'd never get evidence in under the fourth element of this rule.
Sure, but I think what defendant here is almost arguing is sort of the opposite. You have to call him. There's a finding by an appellate division that this witness was credible. That's your new trial strategy. Done. And I'm obviously, I haven't met Sheriff Williams, but I'm looking at his 440 testimony and I'm seeing flaws in it that if I were trying to plan a defense strategy, I'd be seriously concerned about. Most of which I think I would focus that mostly on the physical aspects, so that he couldn't see some of the things that he claimed he saw.
So many things don't make sense in his story. The prior in home invasion, they went to the drug house, they went through the front door. Then, and they used a 22 caliber firearm. They for some reason get a 38. Now, if he said, well, we got a 38 because the 22 is out of bullets, or we need more, I don't know, some explanation. He had no explanation.
Right.
And then why are you going around the second house? Why are you going around back? There's no door there.
Right.
Why?
There's no hallmarks of a home invasion.
Why are you firing into a house simply because a light comes on?
Right.
Like that doesn't help you rob it. His story about, well, Delvin panicked and he shot and ran. Doesn't make it, just run.
Right.
Like, nothing makes sense.
Right.
But it is what troubles me is the standard set by the Court of Appeals. And that's where I struggle. The story seems implausible to me, but I don't know if it's quite that implausible.
And again, I would suggest that the Court of Appeals language that there just has to be some measure of evidence that substantiates the testimony in question. We just don't have that. There's no other independent evidence.
I think what you're referring to is after the Court of Appeals says if the supporting evidence establishes a reasonable possibility the statement might be true. The very next sentence seems to contradict that. It says, this is from the Court of Appeals. It says, even under this lesser standard, however, the proffered evidence must still provide persuasive assurances of trustworthiness.
Right.
Persuasive assurances of trustworthiness seems to be a higher standard than what they just articulated in the prior sentence.
Sure, and it could still be sort of in the same breath a somewhat low standard. You need some, again, I mean, I'll use the language, something to corroborate, something along those lines. But even applying a low standard, there isn't anything. So to the extent that that sentence, so, you know, the persuasive assurance, we have nothing. And in light of that, I don't see how it can be an error to deny the entry of this testimony.
The inconsistency that Justice Lilly points out, because they went right down the driveway. I think it's the next door neighbor's driveway.
Yes.
They went right down the driveway. And the light went on in the story is that there was a panic that caused the shooting. In other words, they didn't go down the driveway to shoot somebody through a window. Wouldn't going down the driveway before a home invasion to case out whatever you could case out to see what's going on in the house be consistent with a home invasion? If they then, do we know in the prior houses whether they cased out the house before they entered through the front door? Do we know that?
It's certainly a possibility. I don't think there was any evidence in the record about the details of the other robberies or burglaries, but you know, even so, that aspect of his testimony, even if again is something that is, you know, could be seen as credible. Right. It still is lacking some sort of corroboration. You know, somebody seeing that happen or you know, something along those lines. I mean, I think I've addressed most of the concerns the panel's expressed, but
Yep.
Okay, thank you very much.
Thank you.
Thank you, Your Honors. I can't say anything else, right?
No, yeah, we're done. Thank you.
Okay, thank you, Your Honors.
Case 121, People versus Remington. Counsel, your opponent, I believe, has submitted.
Yes, Your Honors.
Proceed.
Good morning. May it please the court, Leah Farwell for Appellant Stephen Remington. Your Honor, considering the people have submitted, I will do my best to keep my argument short and just focus on point one of the main brief, ineffective assistance of counsel. The state standard here examines the totality of the circumstances of a particular case and, quote, meaningful representation. Errors that compound to result in prejudice require reversal. Trial counsel here made three compounding errors. First, counsel invited the complainant to comment on the legal determination the jury was there to make. Next, defense counsel confused the jury by drawing their attention to surveillance, by misidentifying his client in irrelevant surveillance footage. And finally, counsel failed to object to prosecutorial misconduct that permeated trial in summation. To the first issue, which is the complainant commenting on the ultimate issue of the case. I drew the comparison in my main brief to expert opinion testimony. The jury has exclusive province to determine the facts of the case. And I think that the most applicable precedent that this court has made or has decided is in People v. Salone, which Presiding Justice Whalen, you were on that panel. And that is where this court exercised its interest of justice review to grant a new trial where a police officer testified as to his opinion on whether or not a homicide occurred. And this court held that testimony that usurps the jury's fact-finding function was inappropriate and grounds for a new trial. Second, as to the surveillance footage, the people argue that ineffectiveness cannot be found where counsel was, quote, trying to support his client's narrative of events. However, I would argue that this is a dangerous precedent. There is no reason for a competent attorney to set forth a theory that is either unvalidated and unresearched or an attempt to distract and confuse the jury. And I think that the Court of Appeals put this best in People v. DeBellis when they said that an attorney's ignorance of a point of law that is fundamental to his case, combined with failure to perform basic research on that point, is a quintessential example of unreasonable performance. And as to the legal strategy argument, a client can make an informed choice about defense strategy after consultation with counsel. However, the client's choice must be truly informed. It must require that an attorney first conduct the necessary investigation to present viable options to his client. And investigation of the law and the facts and the issues that are relevant to the case is essential to any representation. They have an independent obligation to investigate the facts of the case. As to the misconduct point, at summation, the prosecution bolstered their own witnesses' testimony, spoke to their own witnesses' testimony, vouched for their witnesses' truthfulness, and
We have to take a look, don't we, at what was said by defense counsel here and whether or not it was fair comment in relationship to what defense counsel said,
yes, Your Honor.
right?
Yes.
And that's something that we're going to have to take a hard look at.
Yes, I agree. However, I would just say that where the prejudice determination is relevant here, I think that prejudice cannot be dispensed with when Mr. Remington is currently serving a 22-year sentence when he was offered a 10-year plea deal mid-trial after the complainant had testified. I think that shows clear prejudice. And unless there are any further questions from the panel, I will rest on my papers.
Thank you, counsel.
Thank you.
Case 122, People versus Pringle. Proceed, counsel.
Morning, Your Honors. May it please the court, Ryan Bergman on behalf of the appellant in this case, Mr. Pringle. Our contention in this case, Your Honors, is that Mr. Pringle was eligible for YO status and the lower court failed to adjudicate him as such. Primarily, this court, through Garcia, the Court of Appeals, and a long litany of cases, has said that there are generally cases in which information such as age, background, drug habit, upbringing, etc., can't be used in situations for mitigation toward what the elements of the crime are in these cases. However, the fact of the matter is use of the word generally means that there is a universe in which using that information from time to time is, in this court's opinion, reasonable.
What are the mitigating factors that he was entitled to that the court disregarded?
So, Your Honors, I think that when you look at the mitigation report that was submitted on the whole, I think that the PSR in this case, which indicated that the folks that did the PSR in the interviews believed that Mr. Pringle should have been awarded YO. He had a rough upbringing. The information given throughout both the mitigation report and the PSR point to mental health issues, instability of the family.
He was doing well at Heritage House and he really seemed to turn his life around after he got arrested. But the question here, I think, from Justice Greenwood was the mitigating circumstances, as you recognized earlier, have to bear directly upon the manner in which the crime was committed. You seem to be suggesting that that's not a hard and fast rule, because these mitigating circumstances you're talking about, rough upbringing, parents didn't take care of them, mental health issues, those don't bear on the manner in which the crime was committed, do they?
Well, Your Honor, I think that in certain circumstances such as this, where things are as extreme as they are for Mr. Pringle, I think that looking at them I think that looking in those factors in a way to give him the benefit of the doubt basically is what I personally think that the YO.
So we should extend this concept of that bear directly to say bear indirectly or something like that. But
well, no, I think
if you're right, though, that the court, because this was an armed felony.
Correct.
So to get even into the ballpark, one of those two exceptions has to apply. It doesn't sound like you're arguing the second one, that you're just arguing mitigating circumstances. that just gets him into consideration so that the court can exercise its discretion whether to grant it or not.
That's correct.
So if we were to agree with you here, we wouldn't grant him YO, we would send it back and then the court, we would say he's eligible now.
Well, I would think, Your Honor, that underneath the interest of justice jurisdiction that this court has, this court could obviously take a look at the Cruikshank factors and make their determination based on the record here. But if the court were to agree with me, yes, sending it back and then having some kind of re-review of the mitigation reports and all the other factors involved toward potentially granting Mr. Pringle YO status would also be a reasonable
I
outcome.
mean, he didn't get 5 years for shooting somebody twice at point blank range after having already killed somebody when he was 13.
Well, Your Honor,
He had accidentally.
I think that the issue with the previous manslaughter kind of being leveraged in the decision of the lower court as far as not granting the YO adjudication is obviously the record shows that that was something in consideration, shows that this court, the lower court, didn't use the factors correctly. They used the previous case as an aggravating factor without considering any of the factors of mitigation.
Yeah,
Right.
The way the court looked at it, which is how most people look at it, maybe it's incorrect, that he killed somebody 3 years earlier with a handgun, with a gun. He was dancing around and it went off and he killed his good friend.
Accidentally, but
Yes, right. But still, the dangers of possessing loaded firearms, then you would think he would be concerned and deterred from handling such weapons. No, he goes out and he shoots a human being twice at point blank range. Why? Because the victim disrespected his friend and he didn't want to look like a punk. So he, after having already experienced the anguish of taking somebody's life, he's out there with another loaded gun, very closely taking another person's life.
well, Your Honor, then I do think that looking at the mental aspect of Mr. Pringle at the time, then perhaps does reflect on the crime because the information provided in all those reports and all the testimony at mitigation deal with the fact that Mr. Pringle was someone that was susceptible to these sort of kind of impulses and ideas that were put in front of him. That, in my mind, brings up questions to his mental state, which in turn does reflect on the aspect of the crimes that he was indicted on and later pled to. I do think that, again, looking at this on the whole, this court should perhaps exercise its interest of justice jurisdiction if they do find that Mr. Pringle is eligible for YO status and follow the factors from Cruikshank as far as determining whether or not that YO adjudication should be reasonable. And if there are no further questions at this point, I will rest on the remaining papers.
Thank you.
Thank you.
Good morning. May it please the court, Elizabeth Dannon for the people. Our position is obviously that the court did not abuse its discretion in determining that this defendant was ineligible for youthful offender adjudication. We would point out that in cases that defendant has cited where there have been violent crimes and youthful offender adjudication was still permitted was where there was self-defense or extreme emotional distress. Obviously, no such factors here, no mitigating circumstances bear on the commission of this crime. And additionally, I would point out that the Clean Slate Act is going to be in effect for this defendant. So youthful offender adjudication, his record is going to be expunged, cleaned anyway, sealed. If he
This is just a matter of how much longer is he going to be supervised? He's only got a few more years left before he's
yes,
parole.
absolutely. And I would additionally
Sounded like, according to the defense and the mitigation report, the best thing that happened to him was being taken off the street and put in a
Yes.
structured environment.
and
Saved his life. And
And-
now they're saying, well, let's get him out of
right back into those circumstances where he, fell into these same issues. Absolutely no supervision, no support system, nothing. So our argument is that post-release supervision for this defendant is, and some measure of accountability is essential in the interests of justice for this particular defendant. Unless
Any further, counsel?
unless there's any further questions,
There are not. Thank you.
thank you.
Case 123, People versus Jones.
Good morning. Can the court hear me?
Yes, and can you hear us?
I can.
Please proceed, counsel.
Good morning. May it please the court, Melissa Swartz on behalf of appellant Tarkeem Jones. I need to apologize to the court. I'm very under the weather and 6.5 months pregnant, so I'm not as vibrant or quick as I normally would be. I'm going to focus my argument on the first point, which is whether or not the people proved my client's age with legally sufficient proof. There's no testimony whatsoever at trial regarding my client's age, no physical exhibit admitted into evidence that states his date of birth or anything that could be seen as direct evidence.
Was there comment made in opening statement as to his age and date of birth, but then no proof offered during the trial in terms of evidence, correct?
Correct. I believe in opening and potentially in closing, his date of birth was given to the jury. But as this court is well aware, that does not constitute evidence.
There was some photographic evidence, a photograph of the defendant for the jury to see. And there's case law, I think you cited, that as a general rule, that's not sufficient to prove age, which makes sense. But the age here was 18. That's the age that they need to be over.
Correct.
Are there limits to that photographic rule? Like if there's a picture of, say, Dick Van Dyke, the jury can't say he's over 18, or me with my gray hair. Are there any, is it just a hard and fast rule no matter who the photograph is of and the age? Because this one seems pretty obvious he's over 18.
I don't think that you can make an assumption about somebody's age. I don't think that's enough proof. If that were enough proof, then the case law regarding a defendant's appearance in court it's the same thing. The photo and his appearance in court are the same thing. And this court has specifically said that you can't rely on a defendant's appearance, that you need to have something else.
And there's no exceptions to that rule, no matter how old the defendant may be and how low the age might be.
I don't believe that constitutes direct evidence. So I think
it doesn't strike me as a hard item of proof to come up with and to put in a trial either. In other words, I don't see this as a high bar to have to get over.
I think it's the easiest piece of evidence to put in a trial, in my professional opinion. You just have to get a certified birth certificate, or even easier, just have a police officer testify to the defendant's date of birth based on the defendant providing it to them.
There's just a mistake here. I think the DA would acknowledge, maybe he will in a few minutes, it was just inadvertent. They just forgot to put in that proof. And here the effect would be the life comes off the back end.
The life comes on the back end, and the Criminal Sex Act in the first degree is also legally insufficient. But there still exists a conviction that didn't require age. So it would render the sentence a determinate as opposed to an indeterminate sentence. And unless the court has questions for me regarding the other points in my brief, I'll rest on those.
Good luck with your illness, counsel.
Thank you so much.
Counsel, proceed.
Thank you. Thank you. May it please the court, Michael Labella for the respondent, people of the state of New York. I certainly would acknowledge there certainly wasn't any ideal evidence being brought in regards to anything with the age. I would submit, based upon Justice Lindley's comments on the appellant's argument regarding that the photograph's shown, and it was foundational testimony showing that the photograph was around the time of the incident as well. So within like a month or two, I believe it was August 20th, and then the incident occurred June 30th of the same year. Was
the photograph offered for purposes of demonstrating the age?
I don't believe it was, but I also don't believe that doesn't mean it can't be also seen as that.
In other words, it wasn't offered, and comments were made. As you can see, he's clearly over 18 years of age, and his date of birth is. None of that happened.
No, I don't see any of that happening. I did see the closing comments from the summations from the people's side, noting that the element was obvious, listed as date of birth there. I understand that's not evidence at all.
Is there any case law that supports your argument here that a photograph in a trial, supports an age requirement, an element of? There's so many types of cases that age is an issue. So you would have thought it would have come up somewhere.
I had seen in the third department there was a Rosio case where they didn't describe the photograph. However, they did describe that there was additional proof beyond just appearance at the trial. And my argument focuses also on the culmination of the photograph back then and the appearance in the courtroom on top of the other photograph from the photo array as well. So then that a culmination of these can certainly at least provide the jury a reasonable inference.
How about the fact that in the photograph, the defendant had all these tattoos? The law, you gotta be 18 to have a tattoo. I mean, that's really kind of stretching things a bit here, but is that at all relevant? I mean, what if he's, I don't know, there was a mistake made here, right, at trial? And the DA just forgot to put in the proof. So this is what happens. You're grasping, trying to patch things together on your side, but he did have tattoos.
That's why
presumably you can't get that in New York unless you're 18.
that's what I would certainly submit that.
Is that the law, or is it with parental consent? You can get it younger. I'm not sure what the law is. Do you know what it is?
I don't know at this time.
Yeah, okay.
Well, I'm sure there are people in New York who are under 18 that have tattoos.
That's
Doesn't mean
that's
you get
a
it
fair statement as
illegally.
well.
Yeah, you drive a truck through that argument I just made, but in any event, you don't have a whole lot to go with here, right? Doesn't sound like, I haven't heard anything good yet.
I certainly also have there were the statements as well made that can certainly provide some type of, I believe, circumstantial evidence as well. And I would say I'd submit it's more of the culmination of all of this that can still at least provide a valid line of reasoning for the jury to make those possible inferences. And that the photographs would still say certainly at least enough.
Very good.
Thank you.
Counsel, thank you. Case 125, People versus Grace. Proceed, counsel.
Good morning, Fabian Santacroce for James Grace. I'll be addressing points 1, 2, and 3 of my brief. As for point 1, I believe the plea or sentence must be vacated due to the fact the court failed to advise Mr. Grace at the plea of the terms and conditions of probation. Also violated CPL 390-30 sub 6 for failing to provide him with a written copy of such when he was placed on interim probation. There was no signing it, acknowledging it. In essence.
So can I ask you
Yeah.
a question? When he reported to the officer initially, did they give him the conditions and ask him to sign them?
It's unknown from this record. Obviously there are conversations on subsequent court dates about a curfew. So I suppose you can assume so, but can we assume so when the record doesn't show that? I know there was a case argued yesterday where they at least had the terms and conditions signed by the judge at some point. Here, there's no conversation about that. Obviously, the attorney and the judge seem to be unaware of this must be provided. I don't think it's waivable. I don't think it's waivable by the court. I don't think it should be waivable by the defense attorney, especially in this case. Mr. Grace has some issues. I think, 10th grade education. He's applying for SSI benefits. I don't believe based on physical health. Substance abuse issues obviously were the main issue in this case. So I believe that because of that, the plea should be vacated. Obviously, the prosecution talks about. That's exactly where I'm going. So obviously I make the argument, I guess, pose somewhat novel argument that this is an exception to preservation. I believe that interim probation conditions would be a direct consequence of your plea because how you do on those that is determinative of what your final sentence is. And in this case, while it comes up that maybe he wasn't given them, at no point does court or counsel realize they made this error, that they must have done that. So it doesn't really, I don't think there's an opportunity for Mr. Grace to move to withdraw his plea.
Well, look, because I agree with you. There was a clear violation of 390.36. Interim probation, the statute says, as you said, the court must,
yes.
The defendant must receive a written copy, not orally,
Right, I think it's two-pronged. I'm making the two-prong argument here because there are some cases talking about oral leave.
So, and Judge Argento didn't have him there. He was going to gun court, I believe, and there was some indication, well, you'll get him over there. But your contention is that the plea was involuntarily entered. As Justice Greenwood says, and you have to preserve that with a motion to withdraw your plea or to vacate the judgment.
Right.
Here you say, well, do it. This may be a Lopez exception or interest of justice. If your client were to say, look, I didn't get the conditions of interim probation. And then now I'm being charged with not complying with them. If I had known, if only I had known, I would have been on point here. I wouldn't have violated. That I could see as a valid basis to reach your point. But he did things that were obvious. Obviously a violation of any interim probation, regular probation. And he never says, I didn't know the conditions. So
There actually was a time when a defense counsel said, I don't know if he's ever been given these actually in the
right,
record.
given them, but I'm talking about the defendant when he violated. If he said, look, I had no idea I was supposed to be doing that. Okay, maybe, but he doesn't say that, does he?
Well, that's my interpretation of that, of when there was a defense counsel who was covering saying, when they were talking about him violating curfew or something, defense counsel says, has he ever been given them? I have a note here from the defense attorney. I don't know if he was ever told these. And then the court just moves on, is like curfew. So the court just ignores that.
So
So
in a motion, then the defendant could file an affidavit saying, I didn't know my curfew was 10 o'clock, 9 o'clock, whatever it was.
right. I mean, at the end of the day, Judge, I cannot sit here and say that he could have thought it was okay to drink or use drugs, but is this a precedent you want to set, that it's okay for the court not to either verbally advise or to, have, it's not, again, we were talking about it earlier, this is not a hard thing to do. And I don't think the court or defense counsel can waive that CPL 39030, and there's sub 6, and there's reasons for that, because these clients need to understand exactly what they're signing up for. And Justice Argento goes on and on about, you have to follow every one of these terms and conditions, and we don't even know what those terms and conditions are. And I don't know if anyone watched yesterday's argument, but Justice Nowak made an interesting point, which was, okay, like terms and conditions coming to probation office to you soon, like, they're hypothetical at this point when he takes the plea. I understand that it may not fall under preservation, but I think the interest of justice isn't terrible here, because I looked at the Fourth Department's cases, and in the cases where you've said, in this situation where you said that, we're not going to get to it, in those situations, the defendant was advised.
So
And
let's say
that would be
that we go with your argument there, say with interest of justice and clear violation of the statute. What then? You want your client to be, he can't be placed back on interim probation, right?
well, I think he would actually be sentenced to drug court. That's what should have happened here. They should have extended it for a year and sent him to drug court. It was absolutely appropriate. I don't know why anyone didn't raise it. I'm surprised. The judge didn't want to give him 4 years. And that's atypical for Justice Argento. She said, I don't think this sentence is probably not fair at this point in time. And I adjourned it so that we could try to negotiate. I assume that negotiation happened. The DA's office said, well, this is our typical gun court offer, which it's true. I mean, it's due interim. And if you make it, you get the remaining probation. And if you don't, you get 4, which, by the way, is a half year longer than what the minimum is on a CPW2, 3.5. So I think that you should either vacate the plea, or I think at point 1B, I discuss how I think it's perhaps an abuse of discretion to give him that enhanced 4 years, kind of like a due process violation argument. I talk about People v. Richardson. It's a case from this court in 2023 that says, in essence, where the court explains the conditions and
He's scheduled to be released if all has been going well inside. He's scheduled to be released this August.
It's still on his record, though, that he did 4 years. And that's something that I think will always be looked to if he gets in trouble again. I hope he doesn't. He only had 1 misdemeanor conviction here. This was a situation where his mother called the police, and I assume she had regretted that later. And he comes back to the scene and the gun's still on him. I mean, I don't know what to say about it. It's not I don't know. Reality is he was cooperative. He comes back to the scene and has the gun on him.
It does seem like 4 years. A little harsh.
Yes, and the reality is, I don't know if you guys can get to it. the court can get to it, excuse me, because the waiver of appeal, I do argue that it's invalid, but it's a tough one. We obviously have Hannah T. This case is not as egregious as that, but if you're weighing, public interest in the validity of waivers versus, my client's past, if you will, I do think 4 years is, I think that it does weigh in favor of him, even though it's not as egregious as Hannah T. For all the things I've kind of already discussed, but 35 years old, 1 misdemeanor conviction. Mother was incarcerated from early childhood until 21 years old for the attempted murder of a boyfriend, raised by great-grandmother in Mississippi, 10th grade education. Mother also has mental health and substance abuse issues, just like my client. And we're not talking just like, any type of mental health, schizophrenia, bipolar. He's coping with those mental health issues by using drugs, unfortunately. I could go on, I won't bore the court, but I do think I would ask you to either vacate the plea, vacate the sentence, get us somewhere closer to 2. 2 years, what is the minimum he could serve on an attempted
If we
CPW?
vacate the sentence or vacate the plea, we can't give him 2.
Well, no, but I think at that point, there's when it goes back, there's more to, I think that we could hopefully make something work here. So it's not, obviously on a attempted CPW2, incarceration isn't mandatory. I would talk about point 2. Justice Greenwood and Justice Lindley were obviously on the Biles bench. I'm trying to make a slightly different argument. I'm not saying that the court doesn't have jurisdiction to sentence. I'm not saying the court's prohibited from sentencing. The attorney at the trial was obviously making a novel argument that it invalidates giving this enhanced sentence. And I know that in Biles, the court says the next sentence after talking about, it doesn't prohibit sentencing, it doesn't take away jurisdiction, talks about CPL 410 sub 4. I think CPL 400.10 sub 4 is somewhat at odds with 390.36A. I don't think that CPL 400.104 says, okay, yeah, now you can sentence them beyond the year. It says in no event can you, except if you want to send them to the drug treatment program. So I just want the court to take a look at that and see if that's really still where we want to go. And I also thought it was interesting. I really tried to find other case law from other departments, but all the case law I found was about situations where delinquency has been filed and that tolls the time, or defense counsel requests the adjournment. But the 4 departments, the only department who's addressed this situation where it's adjourned over a year over defense counsel's objection. If unless the court has any more questions, I would rest.
Thank you, counsel.
May it please the court, Bridget Field on behalf of the people. Most of these issues were not preserved.
Do we agree there was a violation of the statute there by not providing the defendant a written copy of interim conditions?
I agree that that's what the statute says, but defense counsel, Judge Argento offered to adjourn the plea, and defense counsel clearly waived presentation of the terms to defendant.
Right. She offered to comply with the statute. I'm not sure anyone realized what the statute said. I didn't until I read this case, to be fair. No idea that existed, but you're right. It does seem like more of a waiver than failure to preserve. It's like, no, let's just do it now type deal.
Correct. Judge, the defense counsel was very clear. Judge Argento was quite clear in her offer to put off the plea or take the plea at a later date so as to have the terms of interim probation. She was very clear that you're going to leave this court and you're to head straight to probation where you'll be given the terms of probation.
So if this is a waiver, wouldn't we require a more specific dialogue on the topic of waiver at that moment? In other words, it seems like, and I think Justice Lindley is correct, I think people maybe just didn't realize the requirement here and they were moving the cases along. I don't think it's the defendant is waiving his right under the statute to the interim probation items. And if he was, I think the court had an obligation to articulate that as a waiver and put it on the record. And I don't see that here.
Certainly the record speaks for itself, what was said between Judge Argento and defense counsel. But I think that there's no indication that the terms of interim probation in this case were anything unusual. There's no indication that defendant, contrary to defense counsel's argument, no indication that he didn't get these terms. There on 7 of the 8 court appearances, defense counsel, neither defendant nor defense counsel raised any contention that defendant had not received the terms of interim probation. On one occasion, an attorney stepping in for Ms. Caputo mentioned that he might not have gotten the terms of probation. Defense counsel defendant didn't speak up and say, yes, you're right, I've never seen those terms. 8 different appearances and no mention by, again, with the one exception, no mention that he didn't know what the terms of interim probation were. At sentencing, no contention that he didn't know what the terms were. Certainly with the passage of time in this case and the number of status appearances, if you will, certainly somebody had, defense counsel and defendant had the opportunity to say, you're violating me on a term I didn't know about. And the violations are very general terms of probation, not to abuse substances.
It's not a situation where there's some term that was handwritten into a form.
Correct.
That was unique to this case. And I mean, these are general terms that are just present on this.
Not definitely. And again, something that this is a seasoned defense counsel that represented him at the plea, who would have also known about, what the typical terms of interim probation would have been. And Judge Argento was explicit in that defendant needed to go straight to probation where he would be given those terms. Something that defense counsel, again, could have come to court. They were back in court, I believe, within a month, certainly within 2 months. The defense counsel had the opportunity to alert the court, and again had the opportunity 7 additional times to alert the court, and even at the time that defendant was sentenced.
It did seem like Judge Argento was under the impression that she had to give him 4 once interim probation was violated. Like,
I believe
it's
that
either one or the other, and that doesn't seem to be legally correct, right? She didn't have to give him 4. There was all sorts of, she could have given him an unconditional discharge, I think. Or something far less.
She could have had other options, but I do believe, and I did not review the plea agreement last night, but my understanding or my recollection of the plea agreement was that if he was not successful on interim probation, that the sentence promise was 4 years. I don't know that would have prohibited her from giving him something less, but the plea agreement was for 4 years. So I think that she was certainly justified in imposing 4 years. And I do believe that the appeal waiver was valid in this case. This is not a Hannity situation, so that the whether or not the sentence was harsh or excessive, fails because of the appeal waiver and preservation. If there are no further questions, I would rest on my brief for any other issues.
Thank you, Counsel.
Thank you.
Case 126, Sarah R. versus Rouse Health Hospital, Inc.
Justice Whalen has just stepped out momentarily, but you may proceed. He did not recuse. We're waiting for Mr. Gittin, who is remote. Mr. Gittin is with us, and now, Ms. Felter, you may proceed.
Good morning. May it please the court. Karen Felter from the Smith-Sovic office on behalf of the defendant neonatal group in this case. This appeal, I think there's just really two issues that I think were laid out both in my opening brief and reply brief very succinctly. And that is, first of all, that I do not believe that the hospital met its prima facie burden on the motion for summary judgment in the first instance in connection with the issue of whether there was ostensible agency and the McDougall principle applicable insofar as vicarious liability for that physician group.
Do I understand the law correctly? Those are separate concepts, that ostensible and apparent agency is one way to get Crouse Hospital vicariously liable for
Yes.
the NICU defendants. Failing that, though, there's this MDUBA exception that we call based on a third department case.
Right.
Somebody comes in through the emergency room, they're expected, people are going to be treating them, our hospital employees. Two separate theories here,
Right.
not one.
Yes, that is true. There is
Trial court, it seems like the plaintiff was hanging their hat primarily on the ostensible agency argument based heavily on the name tag worn by Dr. Kern. Dr. Kern being one of the NICU defendants. Name tag says Crouse Hospital. He didn't work for Crouse. And their theory seems to be the plaintiff, seeing that name tag, could have assumed that he worked for Crouse, and therefore that's ostensible agency, based largely on the name tag. Is that how you understand this?
well, I think I'm not sure that the plaintiff mentioned that. I can't recall whether the plaintiff affirmation in opposition to the motion mentioned it, but I know that our affirmation from Dr. Curran certainly did. And I know that the plaintiff's affirmation stated that she, came to the hospital. She certainly was aware that she was there under the care of her own OBGYN, but she did not know that the physicians that took the infant in the immediate aftermath of birth were not employed by the hospital. She said that she was under the impression that they were.
Didn't she say that they told her that they were from the NICU and they were gonna care for the baby? They didn't.
Right. So she said in her deposition, she said that when she was in the recovery room and she was still a little bit out of it, that she recalled a male doctor coming in and telling her that he had the baby, they were taking care of her, she was on every form of life support, and they were doing everything they could to save her life. And at that point, her impression was that that was a physician who was a NICU doctor who was associated with the hospital.
Justice Osmond's point, it's more than that though, isn't it? Isn't it that she was told it was somebody from the NICU? And she doesn't remember who she talked to, but Curran says he could have been, he's the only one possible, isn't
Exactly.
that?
That's exactly right. And the opposition, so in the first instance, that I guess just sort of backing up for one moment, the issue of the prima facie case is important because the motion on the opening papers for the hospital simply made a statement. It was an attorney affirmation stating that there's no evidence in the case that the plaintiff could have been misled at all. But that's just a conclusory statement. There was no evidence. There was no assessment under deposition testimony.
Finding holes in the opponent's proof doesn't meet your initial burden. Here, really, so the agency issue would be she woke up in NICU, she saw Dr. Curran or a male doctor, she didn't know the name, and she assumed that he worked for Crouse rather than some independent outfit.
Right. And she's.
But is that enough? Because the agent has to, by words or conduct, has to lead a patient to believe that he or she works for the hospital. So you're saying just going up to her in the NICU and providing treatment for her, that's conduct that could reasonably form a reliance by the plaintiff?
Well, Dr. Curran stated in his affirmation that there would be no way for a patient to know whether someone from his group, the NICU, was associated with the hospital because of the name tag saying that he's on the Crouse medical staff and he's wearing the same scrubs as the other physicians in the hospital. So he said it would be confusing for a patient and they would have no way of knowing. And she said that she had no way of knowing. So
does that create a question of fact?
I think that it does. And I also think that the additional fact that, Dr. Curran confirmed that, he was the doctor taking care of her. He was, there with his badge at the time. He would have been and wearing those scrubs. It would have been confusing, particularly for this plaintiff who was just coming out of surgery and was in the recovery area when she first encountered Dr. Curran.
Right. I agree with you on the badge. It said Kraus. Anyone seeing that reasonably suspect he works for Kraus, but the plaintiff in her affidavit never says, I even saw the badge or I relied upon the badge. I don't believe she testified to that at all. So again, there has to be reliance. So the badge alone, I don't think gets the plaintiff there and you there because you want the Kraus in too as another defendant. I don't think the badge alone raises an issue of fact because again, the plaintiff, there's no indication that she saw it or relied upon it. So that leaves you with, well, she was in the NICU and she saw a male doctor and it's reasonable for her to assume that they work for Kraus, even though they don't. That's really what it comes down to.
I mean, that's part one. I mean, if you want to talk about ostensible agency and the conduct of the hospital, it's an indirect issue here with the hospital requiring people to wear these badges and, everybody looks alike. There's no way for people to know. That's really not any different than the scenario that led to the Maduba case where, the court is saying, how are patients supposed to know when they come into a hospital that, they're being treated by someone who isn't employed by the hospital?
So maybe.
Well, could I ask a question? Yeah, I'm sorry. So we're here though, let's not forget, we're here on a motion for summary judgment, right?
Right.
And the burden is on the hospital initially. And Justice Looney asked a good question, what's in the record to tell us that she relied on it? On a representation that the doctor worked for the hospital, right?
Yeah.
Is the question, what's in the record that demonstrates that she didn't rely on it? Is there affirmative proof in the record, either in an affidavit or a deposition testimony that says, I did not rely upon the information I saw on the jacket to determine that doctor worked for the hospital or was there on behalf of the hospital? You see that it's a burden shifting thing in my mind, or maybe. And I'm wondering whether or not we have to demonstrate she didn't rely on it at this stage, or that they haven't proven, or they've proven that she didn't affirmatively rely on it.
Well, I think that is the very first issue. It is exactly a burden issue. And that is exactly the point of our appeal, is that on their opening motion, the attorney for the hospital simply stated in a line in their affirmation or memo, though I can't remember actually now that I think about it, but in any event, I think it was the attorney affirmation stating, look, there's no evidence in the record that she relied on any misrepresentation by the hospital. And there wasn't an affirmation by anyone from the hospital describing how it wouldn't be possible or likely for a patient to be misled about the position of the physician from the NICU. So the only thing, in fact, that they put in furtherance of the motion was the contract, which only establishes that there's no employment relationship between the hospital and.
Yeah, I thought that was, and I'm no expert on this by any stretch, but my reading of the cases was the hospital met their initial burden by proving through employment contracts, these defendants, these doctors don't work for us. They are independent contractors. That I thought met the initial burden, shifts to the patient to say, yeah, you don't work for the hospital, but I thought you did because I relied on things that you said or did that gave me that impression wrongly. That's how I thought the burden is, but I could be wrong.
Well, I'm not sure that if you look at the plaintiff's deposition, she was very, still in a state of, I don't know, semi-sedation, had very little recollection of the circumstances. All she said in her affirmation was that she was confused. It was a stressful thing. they thought that the baby could die. And there was nothing that suggested to her that there was anything other than, a physician from the hospital taking care of this baby. So the fact that the treatment occurred, the same way that it would, as it, again, just sort of, tying it in a bridge fashion to the issue in Maduba, that, it creates confusion. And because the Maduba issue is there, I think that, there's a burden on the part of the hospital to say more than, well, she couldn't, there's no evidence in the record that she couldn't, she relied on any misrepresentation. I think that they have to say, she didn't say anything she doesn't remember who she talked to, there's, and this doctor, these doctors wear different scrubs. They identify differently, so it would be very difficult for a patient or unlikely for a patient to be misled. But that's not proof, just saying that there isn't any evidence. So I think when in opposition, the plaintiff's affirmation said, I completely believed that this was somebody from the hospital taking care of my baby. I had no reason to not know that. But the hospital states that she should have known because the doctor, her own OBGYN, told her that the NICU was going to be caring for the baby. And there's a note apparently in her medical chart stating that the patient understood what the doctor said to her. But again, that's not proof that she understood that it was a separate status.
Right. It seems more likely that that this plaintiff thought that the doctors from NICU that she's now suing worked with Dr. Doan. Doan was her physician, didn't work for the hospital, worked for Central New York Women's Healthcare. And would CNYW be Dr. Doan's practice could they be held liable on this ostensible agency theory based on the negligence of the NICU doctors?
No, I don't think so, because I think that the patient was treating with Dr. Doan for the duration of her pregnancy. She certainly knew that doctor had a private practice that she was a patient of. She also knew that he directed her to go to the hospital because they were concerned that, about something on the ultrasound, and that she was going to, deliver this baby. I don't think that there's any more evidence that she would have understood that Dr. Doan was associated somehow with the NICU defendants rather than being associated with the hospital.
Yeah, I'm not sure there's any reasonable evidence that it's reasonable for her to think either.
I think that under this, the case law keeps using this phrase under the attendant circumstances. And I think here, under the attendant circumstances, the patient demonstrated that she believed that this doctor was employed by the hospital. And Dr. Curran stated emphatically that there would be no way for a patient to understand anything different. And they didn't counter that other than just by saying, well, it's not credible. That was the first thing. And that she should have known because her doctor told her that the NICU would probably have to take care of the baby. But, it's an emergency circumstance and this baby's being cared for and whisked away, and she doesn't know who these people are. They never told her, introduced themselves. She was unconscious or under sedation when it all went down. And then when she did talk to the doctor, she was still in a state of, sedation.
You're not asking us to say as a matter of law that there's ostensible agency. You're just saying send it to the jury on that issue.
I absolutely. And as far as the second part of it, which is the Maduba thing, I didn't find any case law that said that Maduba is limited solely and exclusively to situations where a patient comes in through the ER. In fact, it's been extended to radiology services, and the Maduba case itself talks about medical providers in the hospital. So I don't think that that is a fair construction of there is any case law stating that it's limited only to patients who come in through the ER. And in the circumstances here, this is exactly the point of Meduba, where a patient, is getting treatment from a doctor that they have no reason to believe is anything other than someone employed by the hospital, particularly, based on
So
what they're wearing.
you're arguing this wouldn't be an extension of Meduba?
No.
That this falls squarely within Meduba, and in fact, if we found otherwise, we would be limiting to Meduba to only emergency rooms.
Which I don't think is a fair construction of the law.
Are there any cases that apply in Duba outside the emergency room entry context?
I think that I cited one.
Yeah, I can find it.
I think that I did address that issue. I think that
Counsel, we can find it.
Yeah.
If it's in your brief.
well, yeah, I think it is
Yep.
in there. But that's the point I made. And if you don't have any more questions for me, I'll.
No further questions, Counsel. Thank you.
Thank you.
Your Honors, do you hear me?
Yeah, Counsel, we can hear you. Can you hear us?
Yes, I can.
Very
Thank you.
good.
My name's-
Proceed.
My name's Mitchell Giddin, for the plaintiff. Cases that apply Meduba principle, but do not involve a factual setting of entry or admission to the hospital through the emergency room include Syracuse versus Deo. I don't have the page, it's in our brief. And even going back to Hill versus St. Clair Hospital, which is really a seminal case in this kind of line of cases. I'd like to just address this burden issue because sometimes there's a difference between the ultimate burden on summary judgment, the burden of going forward to show a prima facie case, eliminating issues of fact. Even the PASIC versus Catholic Health Services, which was relied upon by the court below in its decision, in that case, it's distinguished because in that case, there was clear and indisputable evidence that eliminated ostensible agency. And I think that the cases show that the ultimate burden on summary judgment to eliminate issues of fact is to eliminate exceptions to the general ordinary rule of no vicarious liability for non-employees. It's interesting that in PASIC, although we didn't have it in the parties' briefs last March, this court decided and cited PASIC and Sweeney versus Niagara Lutheran at 236 AD 3rd, 1492. And Your Honors, Judge Lindsay, Judge Whalen, Judge Hanna were on that panel. You may recall the writing that in that case was found that ostensible agency was not applicable for the reason because the hospital established that the patient could not have reasonably believed that the negligent doctor was acting on the hospital's behalf or that the hospital chose the doctor. I suggest, I believe that that indicates that that's part of the requirement or the requisites for summary judgment in this kind of setting in favor of a hospital to eliminate those exceptions. We know that Dr. Doan, the obstetrician, did not select Dr. Curran or any of the neonatal defendants who worked in the NICU. If I may, I just want to return briefly because Judge Lindley was asking Ms. Felter about what the patient might have thought or whose burden to establish what the patient thought. The best evidence we have is the patient's word that she was given the impression that the NICU doctors were providing care on behalf of the hospital. Going back, if we had this to do again, we could have had her say, I relied on it, but she can't say that she relied on a badge because she doesn't remember seeing Dr. Curran. All right, she doesn't remember his name. She just remembers seeing the person who was in fact Dr. Curran. So when we look at the totality of the circumstances, we know that it was Dr. Curran, all right, notwithstanding that there are a lot of NICU doctors who get involved in the baby's care. They're all named defendants. But in addition to the badge, whether or not a woozy patient notices a badge, Dr. Curran explained in his affidavit that not only the badge, but the hospital scrubs, that he was issued scrubs that were identical to what all the residents wore and what all the other doctors in the hospital, presumably the anesthesiologist who assisted at the C-section and Dr. Doan, the private doctor. So I think we have to honor that. You know, the testimony was very limited. There was not very many questions, only a handful, if that many, about the initial contact with Dr. Curran that the plaintiff had. So we're really left with the situation of drawing the reasonable inferences that are in favor of the party opposing summary judgment, that under all the attendant circumstances, not only was the plaintiff given the impression, but that Dr. Curran and all the NICU doctors were providing care on behalf of the hospital, but that she relied on that apparent fact, and she had no reason to question it. I've spoken about a ostensible agency. You know, I think that the concept is related to, although we can distinguish it from what's been called or evolved to be called the emergency room doctrine. It's not truly an emergency room doctrine, but it's, you know, when Maduba is cited, that term is used frequently. And I did have a separate point that, you know, that invited the court to liken specifically the NICU from the perspective of a newborn to an emergency room. But really, on the issues that's very squarely presented here, we cited the TART case, for instance, where a baby had infection. I think it resulted, if I remember, in an amputation of a finger because of an IV infiltration. Now, that was not a case where the treatment of the baby had anything to do with an emergency. It was a failure to monitor an IV line by a private professional corporation that was operated the NICU at St. Barnabas Hospital in the Bronx. It was just happenstance or immaterial that the plaintiff, the baby's mother, came in through the emergency room. And there's no principal distinction, and certainly none drawn by the defendant, Krause Hospital, in its brief to distinguish that case, nor is the case of Quinn versus the United States, you know, applying New York law, where there was the initial emergency was not material to the allegedly negligent care. Returning to briefly Ms. Rice's state of mind, she explains in her affidavit that I think this goes to Judge Lindley's question that was posed previously. How could maybe she assumed perhaps that the NICU care was provided by the same group that she got her prenatal care with, the obstetrical group. But she explains that, you know, she had intended to have her newborn cared for by the same pediatricians who provided regular pediatric care for her other children. But, you know, this was presented as an emergency. And so that kind of cuts against any assumption that she may have had about NICU doctors providing care on some basis other than having been furnished by the hospital itself. Lastly, if there are no questions on these points, and I acknowledge jumping around a bit to fill in what the co-appellant hadn't already covered, I would suggest that just from basic fairness and equal treatment, that we can, however it's phrased or categorized, that from the perspective of the newborn, okay, that she didn't present to any particular doctor. That's where she was. And there was no way for this hospital, pursuant to its own contract with the neonatal defendants professional corporation, to provide any care, to allow anyone else to care for the infant. So I think a lot of the language that's used about reliance by a patient and what they may know can really be put aside. And that's why we said as an alternative grounds for holding is to liken or equate the NICU treatment in an emergency now for a newborn who comes straight from the delivery room. And whether that's an extension or a further application of.
That just sounds like a new rule. It sounds like a new rule for infants who, look, the apparent theory doesn't fit this infant, would have no reason to be sitting there when you're born, like, wait a minute, do you work for Kraus? Or they don't know anything.
They don't know anything, right? I mean, and that's why I
the
said,
whole theory doesn't apply there. So what you might be saying, it sounds like a decent rule, is there's agency as a matter of law in that situation, no matter what.
yeah, we put that in as a separate point, because while I do believe that you only need to apply Meduva by its terms and by its history without making any new rule, we put it in if the court were to conclude that there's insufficient evidence of reliance by the parent, who's not the patient anyway, but by the plaintiff, then it is a fallback, and we'll be talking about this in Albany a year from now. But again, I say that's an alternative, because I think that, and you know, in fairness to our client and to really do justice to this case, that ought to be in the background. But then it's up to a court, a common law court, to furnish rules that would cabin any additional or further exception to the, you know, general no vicarious liability rule. I'm not urging that at all as our primary, you know, contention. Our primary contention is that there are fact issues here, okay? Whether or not you even consider Dr. Curran's and the plaintiff's affidavits. But certainly when you do consider their affidavits, it's inescapable that, and we have in this precedence, the Hart case, the Quinn case, Syracuse versus Dale, that when this is not a referral situation. That's why I believe that the hospital in its brief and in its papers below talked about Dr. Doan having engaged Dr. Curran to come to the delivery room because there was going to be an emergency C-section. That choice of language is telling, I think. I mean, he didn't engage. The private OB did not engage the NICU. There was not like regular procedure. They have to notify the NICU there's going to be an emergency C-section, and the hospital makes the rules, and the standard of care makes the rules for how to provide care to a preterm. Well, I don't want to go into the facts of it, but when the emergency basis, because of the fetal ascites was seen, everything unfolded from there. So,
counsel, you should wrap up.
Yes, I appreciate that, Judge. We'll rest on what we say in our opening and in our reply brief. Thank you, judges.
Thank you, counsel.
Good morning or good afternoon, Your Honors. If it pleases the court, Matthew Van Beveren, Gail Galen Hunt, on behalf of Cross Hospital. I'm going to move off my argument. I'm going to just address some of the points that were raised by Your Honors. With respect to the burden in the first instance, my understanding, and I think Judge Lindley pointed out, is our burden in the first instance as the hospital for a vicarious liability claim is not our employee. And we established that in the first instance through the affidavit of Mr. Grasso. We have the contract. I don't think there's any doubt that the NICU people are not our employees. So that's our burden in the first instance, again, on a vicarious liability claim. Once we get past that, now they have to raise some sort of exceptions, what I would call exceptions, in opposition to create an issue of fact, right? So control, we talked about control. We have the contract, which does not control. But what we're really focusing on is the apparent agency. And I just want to make clear that it's our position that what Dr. Curran believes or what the patient herself believes on its own, frankly, is irrelevant. What you really have to focus on is the relationship.
Let me stop you for just so I can maybe try and get my head around this a little bit. In the pleadings, the apparent agency issue was raised, right? In the pleadings.
Okay.
I'm asking.
I actually don't know if it was raised in the pleadings.
Oh, all right. So let's assume for the sake of argument it was.
Right.
It's raised. In other words, you're on notice that that's what they're claiming. Look at this we understood that the doctors that are presenting with the name tags in Crouse Hospital and the medical garb are Crouse Hospital employees. There's a parent authority. Okay, let's assume that that's raised somehow in the pleadings of the bill of particulars. And so when you come to the motion for summary judgment, don't you have an obligation on the motion itself to take care of that, to say there are no issues of fact regarding what's being contested in this case?
Right.
And it's our burden to demonstrate that. We can't simply say part of it, and so therefore we got over our burden, and let's let them see if they show us the proof that you have, because that gets into you're popping holes in proof, and we don't do that.
Yep.
Right on these motions because it's a drastic remedy.
Sure.
Right. So you're saying I'm not looking at that the right way.
Judge, I'm not saying that. All I'm saying is my interpretation of the case law is that for a hospital in these cases, their burden in the first instance is just to simply establish no employment relationship. They're not our employees. That is my understanding of the case law. And I believe it's in our brief that is our burden in the first instance, that we do not have to go through control type arguments, submit a contract, that we don't have to raise on our own in the first instance.
Regardless of what the allegations of the complaint are.
I'm sorry, Judge.
Regardless of the allegations of the complaint. If the complaint says we understand they don't work there, but you thought they did and we relied reasonably on some conduct. You just could say we don't work there and you meet your burden. I mean, we already know you don't work there.
I believe that's true.
The ball down the field.
Yeah, I still believe that's the burden first.
Okay.
I mean, and I do think, looking at the pleadings and the bill of particulars, sure, I mean, they raise all kinds of theories of liability and they say the hospital's liable for everybody under the sun, right? I mean, it's everybody. And so, yeah, we demand
the son, anyone working in the hospital that's wearing the scrubs and the ID.
sometimes more than that too, Judge. But
that's what they're referring to here.
Yeah.
But your gist of your argument, I think, is what Dr. Curran thinks that the plaintiff may have thought is irrelevant. Curran goes through like, hey, I had this badge on. She might have thought it's really what did the mother think?
Absolutely, Judge. I think that's
the mother's affidavit. It's a very short affidavit. There's 8 paragraphs. The only thing I see, she doesn't mention the badge.
Yeah.
She says the only reason she was given the impression that the NICU doctors were providing care on behalf of the hospital is that the doctor in the NICU, one of the doctors approached her in the recovery room.
Yes, Judge.
And that's the sole basis of the apparent agency allegation is that.
I think
so. That's the case rises or falls on somebody from NICU comes up to her and she says, is it reasonable for her to rely on that and say, oh, you work for Crouse?
I think that's right, Judge. I think if you look at the cases and counsel, Mr. Gittin pointed out the PASIC case, absolutely, that's this court's decision a few years ago talks about this. And PASIC cites to Thurman and King, which I think are the other 2 important cases. Those 3 cases read in concert, it fits comfortably into this fact pattern. There's nothing new or surprising about this case. What you're looking at is the relationship between Mrs. Rice and the hospital. She gets to the hospital only because of her own private attending, right? So that gets rid of vicarious liability through, if you want to call it Meduba. And they do want to extend Meduba, no matter what they say. If the court agrees with them on this Meduba, it absolutely extends it. And in my view, inappropriately.
They say reading Meduba, it reads only to emergency room admissions.
Absolutely.
And that's all it stands for, nothing more.
That's our position. And that's my reading of the case law. I could not find a case.
They say they have case law and counsel was opening the brief there. And
but
Mr. Gitlin said he's got cases that, are you aware of the cases that they're relying on for this?
I don't, but here's my reading of Meduba and why I don't think there's a case out there. We can't get away from apparent agency principles, right? That's what underpins this. And Meduba, as I read Meduba, is essentially a little bit of a shortcut, right? The court's determined the hospital just existing and being in a community, people know it exists, it has an emergency room. I read Meduba as a short circuit for the holding out and reliance, right? That's my understanding for the rationale of Meduba. You don't have to prove the holding out and reliance because a hospital existing in the community is holding itself out, is providing certain services. Now, not all hospitals have NICUs. Not all hospitals have other services, right? So you look at the holding out of the principal, in this case, the Crouse. What have they held out? To Mrs. Rice specifically? Nothing, because she's there because of Dr. Dove, her doctor. Now there's a trust between a patient and a doctor that the hospital's not involved in at all, right? You select your prenatal care provider and your delivering provider because you feel comfortable with that provider, right? You like the office, you like the colleagues in that office, you know where they deliver. And who picks that? Dr. Doan. She delivers there, not because Krause compels her. She picks that hospital. So you get the patient in, there's no apparent agency. The only reason she's there, not because the hospital is holding out or her reliance, right? It's because of the relationship with Dr. Doan. And then once she's there, Dr. Doan is managing her care. The relationship still flows primarily through Dr. Doan, right? She's entering order. She's ordering tests. She engages MFM, the maternal fetal, Dr. Spidola. She engages Dr. Cran for the NICU unit, right? And there's case law that says referrals from a private physician to another physician in the hospital, no apparent agency, because that doctor's the one. The patient picks that doctor. I trust my doctor to make medical decisions. And her role does not end as soon as the baby comes out, right? You're trusting that doctor through the labor, through the delivery, and safe delivery after for the baby. And that's what Dr. Doan's doing here.
So in the relationship here, the expectation was that she would go into the hospital because that's where Doan had privileges.
Yeah.
And the baby to be delivered.
Yeah.
And all was good.
That's exactly.
Right?
Right.
But that's not what happened here.
True.
Right? And so once the expectations and what was going to happen didn't happen, and there became an emergency situation, which I don't think there might be, but I don't remember seeing anything indicating that Doan said, hey, look, there's a NICU unit. That's why I use this hospital. And if there's a problem, it's a great group that I have a relationship with, and they're going to step in. There's none of that in this record.
Correct.
Right?
Right.
Yeah. And so what happens once there's an emergency is really what we're focusing on here, right?
Well,
and I don't know that was contemplated by the relationship between the patient and the doctor and her decision to go to this hospital.
Sure.
I don't think that was part of the understanding. So we're kind of operating outside of that.
I guess, I think we're speculating a little bit. We may or may, I mean, it may or may not have been a part of the conversation that Mrs. Rice had with Dr. Doan. I mean, certainly anecdotally in my own experience, that is a conversation you do have, that the delivering provider is responsible. But again, setting that aside for a minute, we still have to look at what was the holding out to Mrs. Rice for the NICU. It's just not there.
Well, I mean, your argument is Dr. Kern's affidavit is totally speculative.
That, in my view, Judge, yes, Dr. Kern's affidavit gets us nowhere. It's not relevant on this motion because he's not an agent of the principal at all. He's a private physician. The conduct, the holding out has to come from the principal. And if you look at the cases cited by, I believe it was Mr. Ginn, the Dragota case, second department, there was pre-anesthesia testing. Like, so that creates a little issue factor, right? Like they go into the anesthesia group beforehand at the hospital. That's something. We don't have that here. In the Quinn case, they send a letter. The hospital sends a letter saying, something about our neonatologist, right? That's Krause Hospital, or not Krause, that hospital saying, this is, so that creates an issue of fact. None of that is here. We have Coran's affidavit really doesn't get us anywhere. And Mrs. Rice's affidavit, I don't know who I was talking to at any, understandably, that's just the facts of this particular case. I don't know who. Someone came and said it was fine. Now, did you accept NICU services based on a relationship between the NICU doctors and Krause and then rely on that?
Does it matter?
There's none of that.
Let me ask you this. Would it matter at all on this if a patient, and we're talking about Mrs. Rice here, a patient were to hear NICU and we're to say, what does that stand for? And it ends in unit, that would be part of the hospital.
That would be part. Well,
it's being referred to as a unit.
Okay.
Right?
Yeah. I still think that doesn't get us here, Judge. I still think you need a holding out from the principal. I think that's the underlying bedrock for parent agency principles.
And the name itself doesn't do that.
Not on itself. I don't think so. And I think the case law is supportive of that. Certainly the Thurman case talks about what we were talking about earlier, the badge and That's not enough. It's just simply not enough.
It was, on there, it was like stationary logo.
Yeah,
It
exactly.
was a little different, but
A little different, but
we
still.
don't know if the patient saw the
We
stationary.
have no idea if she appreciated any sort of significance beyond this. And her not knowing and Curran saying, well, who would know? Maybe all true, irrelevant though on this, but doesn't get them there. They're not employees. They didn't put enough evidence in opposition to get past this. And I think that the trial court correctly granted our motion, and we would ask you to affirm.
Thank you, counsel.
Thank you, judges.
Case 127, Ordway versus Taylor. Counsel, my understanding is the appellant has submitted.
That's my understanding as well, you guys. Good morning, Your Honors. May it please the court, Nicholas Michael Rossi on behalf of defendant respondent Michael A. Taylor. The motion before this court, on that motion, the plaintiff bears the burden of establishing both a reasonable excuse for the delay as well as a meritorious defense to the underlying action. And case law establishes that that is left to the sound discretion of the trial court.
Law office failure is a reasonable excuse now, right?
It can in certain
Because
circumstances.
this was law office failure, right, left, and center.
So there's essentially 2 points in terms of what they claimed. Initially, at the time of the argument of the underlying summary judgment motion, the initial position was that plaintiff's counsel was looking for some unspecified evidentiary materials that were somehow relevant to the summary judgment analysis. Now, they've kind of abandoned that. We never heard what those were.
The first argument was that they thought it was on submission instead of oral argument. Right?
Yes, in the trial court.
The other part of your argument is they keep changing their excuse.
Well, they have two separate excuses, but on the motion that's presently before the court, the motion to vacate, the argument was that it was, yes, law office failure. And there is case law that says that can be a justification, but there's case law that also says it's clearly not the case. And we've cited that in our
Right, well, we've got a delay that very minimal. 7 days, no prejudice whatsoever. Those factors militate in favor of giving a plaintiff their day in court on the motion.
I understand that. And our position would be, even if you get past, let's get rid of the excuse for the delay. They have to establish both the excuse for the delay and also a meritorious defense. So let's assume they didn't, but let's assume they did establish the excuse. They still have to establish the meritorious defense. In the underlying summary judgment motion, I understand they didn't have any formal papers in, but all of the transcripts, all of the evidentiary materials were before the court. And the court certainly reviewed the record. And this was not a situation where the trial court simply said, well, there's no opposition, we're going to grant it, Mr. Rossi, prepare an order.
Yeah, that's a legitimate point you make, because I looked at that decision from Judge Cook on summary judgment. I don't agree with it. But the plaintiff hasn't appealed that. Even without any proof from the plaintiff, Judge Cook didn't say, I'm tossing this complaint. It said, it's going to rule on summary judgment motion without their opposition. And there's just reliance on Mr. Taylor was driving 55. Why do we know he's driving 55? Why is that written in concrete? Because he said it. That doesn't make any sense. I mean, the other side is not in any position to challenge that. But that's the merits of the summary judgment motion. Our appeal is for the motion to vacate.
Correct.
And so my concerns on the validity of the granting summary judgment, even in opposition to even with no opposition, that's not before us.
It's not before us, but I think it's certainly relevant to the second component, because if we're talking about whether the plaintiff has a meritorious defense to the underlying motion, then we have to get into the summary judgment. And I would submit that based upon this record, I mean, my client clearly testified he was traveling no more than 55 miles per hour. He testified.
Is there any black box evidence of that? Anyone sitting there on the road doing radar?
No, there wasn't.
Right. So we're basing it on his word. And
Right.
there's case law from this court and the Court of Appeals, everyone that says for summary judgment purposes, testimony from one party who's in exclusive control of that knowledge and the other side is not in a position to controvert it, that does not establish as a matter of law what the person's saying. In other words, it should go to the jury to determine whether Mr. Taylor was actually going 55 like he said. seems highly unlikely on that road. He was, but the trial court, everyone just, I think plaintiff even just took his 55 at face value. So who am I to challenge it?
Well, I think the problem with that would be that how could we, if we get into that, how could he ever establish how fast he was going other than his testimony if he doesn't have black box?
Well, he testifies to it. That's how he establishes it, but he does that at trial, not on a motion for summary judgment.
Right, but I mean, for the purposes of the proof that's in the record, all he can do is establish how he was operating at that time.
But that doesn't establish it as a matter of fact. In other words, simply him saying it does not, as a party to the suit, does not allow for us to say, oh, well, that must be true then.
Well, I think it establishes a prima facie case, at least relative to summary judgment.
Subject to cross-examination.
And they had.
Well, let me ask you a question about the meritorious issue here.
I'm sorry, what issue, Judge?
The merits of this, right? That's what we're talking about. Your client testifies, I believe, and correct me if I'm wrong, that he's familiar with this roadway. He goes up and down it in more than a few occasions.
That's correct.
Right?
He lives in that area.
Right.
Is my understanding.
So he would know, because he lives in the area, about the dip and about the site limitations on the road that I think are outlined in the papers before us.
Yes.
All right. So he'd also saw the other car at a stop and with an indication that they're waiting to turn left. He saw that too.
He testified, both parties, both the plaintiff and.
I'm talking about him.
No, I understand that. Yes.
Yeah.
He testified that he saw the other vehicle when it was at a stop.
Correct. That's what I'm saying.
Right.
Right. And he's traveling down the road. He sees that car. He knows about the sightline limitations. And he says he's going 55. And he doesn't slow down as he approaches there.
I think much.
Is that a possible argument for liability the jury ought to be contemplating?
I think much has been made of this sight line, and I think it's a bit of a red herring. They both testified that each saw the other vehicle when plaintiff's vehicle was stopped. There was no indication that any sight lines with the road changed that from the point that the two vehicles saw each other. There may have been a sight obstruction at some point, but both clearly
was at some point.
But both clearly testified.
So you don't think if this were a trial, like there's any possibility Taylor could be, say, 2% found contributory at fault, 5%, 10%?
I would say that all I can go on at this
Zero?
point is the basis of the record and the testimony, and I believe that the record clearly establishes that there's nothing creating a question of fact.
Well, the driver making the left, who did make the left, isn't there testimony in the record that indicated that she thought your client was speeding up as she was making the left?
So the driver of the other vehicle has never been deposed. The only two parties that were deposed were my client and the plaintiff, who was a front seat passenger. Now, what the plaintiff said.
That's the testimony I'm referring to.
That's the testimony you're referring to. I believe at one point she testified that she thought the speed limit on the roadway was somewhere in the range of 30 miles per hour. She did not see any speed signs. She wasn't familiar with the area. She didn't know where they were going. She testifies that she sees my client coming. And then at some point, she looks out the right window. And I believe her testimony was that she continued to look out the window through the point where that vehicle was making the turn. Now, she threw in some testimony about, I think he was going fast. Nothing more than that. Never anything.
Did she use the word fast or was speeding up or accelerating? What do you remember the language that she used?
I believe.
I'd have to go back to the record.
I believe she used the term that he was driving fast. That's my recollection.
I'll take a look at
it.
Unless she's got some radar gun, you're asking her, it's an impossible task to say raise an issue of fact on speed. If Taylor were going 70, do you think there'd be at least an issue of fact on contributory negligence here?
If he were going 70, I think that's a different situation.
55, maybe.
But I think in that situation, you've got an explicit statutory violation.
Right, but here we're just accepting his word for it, 55, and why? Because he said it.
Well, I think
it doesn't seem like the principle of law that we should apply.
I understand the court's concern, but I think if he's in a position to testify, yes, I'm familiar with the roadway, I travel it frequently, I know the speed limit, and I have a specific recollection of the speed that I was traveling on the day, I don't know what else we could ask for someone.
And if the record reveals, and I'll take a look at what the specific language, if the record reveals that the witness in the other car says, as they were approaching me, they appeared to be speeding up or going fast or faster. In other words, not slowing down. We should take that at its word similarly. And wouldn't that be something that a jury ought to contemplate who's to be believed?
I think there's got to be a little bit more of a basis to get past the point of speculation, which this court has repeatedly held insufficient to create a question of fact relative to negligence. I think you have to have some basis from that individual as to why they think he was going quote unquote fast. If someone believes the speed limit's 30 miles an hour and my client's going 50 and the speed limit is 55 miles per hour, that could certainly be a subjective interpretation of going fast while still not constituting any form of negligence.
Was that issue explored at the deposition so that it got cleaned up and it became clear what she meant by that?
I asked her, relative to her interpretations of speed, I asked the plaintiff whether she knew what the speed limit was, whether she had any basis to make an actual determination of the other speed. And my recollection is that she didn't have any basis. She just used the term fast. So I think we're in a position where, and based upon the testimony, my client clearly testified he saw the other vehicle while it was stopped. He then testified that the other vehicle did not start the left turn until there was only approximately 10 to 15 feet between the two vehicles. In that time, he applied the brakes and attempted to move the vehicle to avoid the accident. Obviously, he was unsuccessful in doing so, but we've cited several cases where this court has held that an individual proceeding with the right of way in a lawful fashion
alleged lawful fashion.
Part of her reasoning for him driving too fast, in her estimation, correct me if I'm wrong from the record, isn't it because of the topography and the hill that when she could see his car?
I don't know that she specifically connected the topography of the scene with the speed.
Talk about the hill. You couldn't see the car because of the hill, no?
She mentioned the hill, but her testimony was that she testified, and I'm talking plaintiff, front seat passenger. She sees my client's vehicle. She tells the motorist, the driver, who was never deposed, that she saw this vehicle. And then I believe her testimony was she looked out the side window. That driver then started the turn at some point after that. And my client testified relative to the distance between the two vehicles at the point that he observed the other vehicle begin the turn.
You spend most of your time talking about meritorious defense, less on excusable default. It was a lot of these arguments go to the merits of the summary judgment motion and at trial, but it seems I have a problem saying 7-day delay of this nature with no prejudice, that it was not an abuse of discretion for the judge to say, I'm not going to consider anything you give me. That's the problem I have. But as you say, we got to get to the meritorious defense as well.
Well, moving from the meritorious defense, I think the trial court was correct in finding that this was not a reasonable excuse. And we get back to what was the actual excuse. Initially, it was, we're looking for some evidentiary materials.
The lawyer messed up.
But isn't the
and then probably lied about it. Yeah. Lawyer messed up and tried to come up with all kinds of lies.
Well, I understand that, but
isn't the problem here that to give a reasonable excuse, you're supposed to lay it out in detail, and he didn't do that.
Well, I think he certainly attempted to. So we had a motion argument on the record in November of 2024, and that's where the trial court addressed what the plaintiff was claiming relative to that reasonable excuse. And the court specifically said, well, if you thought that this was on submission, that might excuse your failure to appear, but it doesn't your failure to timely file an opposition by September 3rd of 2024 based upon the notice of motion. The other component to that, though, is that this motion seeks to essentially put the underlying summary judgment motion back on the calendar. Plaintiff's counsel has filed an untimely response. It wasn't considered, but it's been filed. We know what it is. I would submit there's nothing in that changes the negligence analysis. There are no new evidentiary.
Well, let me address that just for a second. And maybe I'm misunderstanding this, so do correct me. But I thought what happened here is there was the plaintiff's counsel reached out and said, look, we've got this motion scheduled. would you grant an adjournment of this? I've got some other things I want to develop to put into my papers. Isn't there some indication of the record that happened?
Yeah, so the motion argument on the underlying summary judgment motion, I believe, was September 10th. After 5 p.m. on September 9th, I received an email from plaintiff's counsel's motion. I didn't get to it till the next morning, which was the motion argument date.
But my point is, it was during that communication. I'm not worried about when you got to it, and I understand that. It was that communication was indicating there was a desire for an adjournment of the motion that was scheduled for the next day.
It was scheduled for that afternoon. Yes, they requested an adjournment, and the basis for that request was this unspecified evidentiary materials.
And the argument is, but then we got the papers and there was no additional evidence contained in there.
Yes.
Well, counsel at that point was under the gun to get something to the court, right? Because the adjournment wasn't granted. Counsel had to get what they had to the court. I don't know that there's an assumption that we should be making that counsel, had they gotten an adjournment, would not have been providing additional information. You're just saying that what we got, they already knew all about this. They didn't supplement it with anything. Well, he was saying he needed time to supplement it. So I casting aspersions on him for not adding things when you don't grant the adjournment, that he gives him the time he's asking for to collect that information, seems a little disingenuous.
I certainly wasn't trying to be disingenuous. Where I was coming from was the note of issue had been filed on 2 separate occasions in this case at the time of that. It had been filed once, we vacated it. They filed it again. The day of motion argument on a summary judgment motion, after filing the note of issue twice, I'm being told for the first time about unspecified evidentiary materials, which, by the way, haven't been identified. And that was how I responded to it.
Right.
I didn't grant the adjournment request, but I said, you know, we're now talking about unspecified evidentiary materials that somehow relate to the negligence analysis. We've got a motion argument on a summary judgment motion in 2 hours. That was essentially.
I just don't know that we should automatically jump to an officer of the court, misleading the court, misleading you by saying that they need an adjournment to get additional information. And then when you get the papers that he had to rush on, it didn't contain additional information. That's all I'm saying.
I'm not implying that he was misleading the court in any way. I'm just saying at this point, they haven't been identified and we're now however long past that point. I don't know what those materials were, if they ever did exist. I'm not implying he was misleading.
I think bottom line, last word that for me is that what I've seen from some judges who've practiced criminal law and they get into civil law is they treat scheduling orders like it's speedy trial or there's some statutory direction from the legislature, and it's not the same thing. And this is such a minimal extension and delay with no prejudice. This is not speedy trial, and civil's a little different. And we have a strong preference for deciding cases on the merits. That was my concern looking at this, but you've got some legitimate arguments on your side as well.
Thank you, Honor. If there are no further questions from the panel, I'd submit on my papers.
Thank you, counsel.
Thank you.
Case 129, Nims versus Riley, MD.
Your Honors, may it please the court?
Hold on 1 second. We want to make sure. Mr. Schoonmaker?
Apologies.
Yes, Your Honor.
You're on and you can hear us?
I am, Your Honor.
Okay, very good. And counsel, tell me who you're representing and are you going first?
I should go first. I believe Mr. Schoonmaker is only has a vicarious liability.
There you go. Let's do that.
I'm John Caniglio. I represent appellant Mrs. Walker and her employer Jefferson Anesthesiology. The basic complaint here in this medical malpractice case was a failure to recognize and diagnose deep vein thrombosis, which is a vascular condition. A brief factual summary respective to Ms. Walker was that the plaintiff had chronic knee pain for 4 months, went to Ms. Walker for pain management of that knee, and by plaintiff's own admission, was thoroughly evaluated and taken seriously by Ms. Walker.
Nurse, she's a nurse, right? Registered
nurse practitioner.
Nurse practitioner. She saw her one day, August 8th of 2000. One day.
One outpatient appointment on that day.
Then she referred the plaintiff to Dr. Riley.
Correct. She considered. Go ahead.
Her negligence, if any, occurred on that one day, and I think the allegation is she should have done ultrasound or referred her to an ultrasound immediately, something along those lines. Do I have that right?
You do. To put a bit of a finer point on it, it was the one outpatient office visit. Ms. Walker considered vascular etiology based on the history and the examination of the plaintiff, referred the plaintiff to a vascular surgeon, Dr. Riley, the co-defendant here. And the allegation is there should have been an urgent/emergent ultrasound ordered by Ms. Walker.
Okay. So, but we have an expert from the plaintiff, a redacted expert affidavit, which says Nurse Walker deviated from the accepted standard of care, should have. These signs should have been enough to alert her to the possibility of DVT, and you should have taken this course of action, which was not taken. So we've got Nurse Walker's affidavit saying I did everything right. You got a PhD expert saying no, you didn't. Usually that's what battle experts, we send that to the jury. Why shouldn't we do that here?
Because a lot of the factual basis for and reasoning of Ms. Walker and her affidavit was unaddressed by plaintiff's expert in his or her affirmation, namely that Ms. Walker did not see any emergent symptoms of DVT that would have warranted a referral to the emergency department for an ultrasound. So the allegation is that there should have been a urgent emergent ultrasound. And the functionality of that, how that would have been possible, was that Ms. Walker was to refer the patient to the emergency department. There was just no indication for that. That reasoning was not addressed at all by the physiologist, plaintiff's expert in the affidavit. And not only that, the referral, nor does the expert address why the referral to a vascular surgeon did not meet the standard of care, why that decision, that judgment, as opposed to an urgent ultrasound, constituted the wrong decision. And in any event, the patient did see the vascular surgeon, Dr. Riley, prior to the claimed injury here, which was a pulmonary embolism. So the patient did end up with the specialist, the vascular surgeon who specializes in the vascular conditions of which DVT is, before the claimed injuries in this case. So it's not addressed.
There's a causation issue?
There is, that does touch on causation, but it also shows that, the vascular affidavit of the plaintiff also says an ultrasound should have been performed on August 22nd or 23rd. Plaintiff saw Dr. Riley on the 22nd. That's a tacit admission that Ms. Walker correctly, pursuant to the standard of care, got the patient in the hands of the specialist, who himself, number one, didn't think there was DVT, but in any event ordered an ultrasound. So that reasoning went unaddressed by the plaintiff's expert in the affirmation, amongst other things, including, so I submit, defendant, appellant submits that Ms. Walker's care and treatment, the scope of her care ended on August 8th. But there's also this new allegation on motion where Ms. Walker allegedly had a duty to ensure that Dr. Riley timely ordered his own ultrasound, and that would have been on August 22nd. Ms. Walker addressed that in her affidavit as well. She didn't assume any care over another physician's decision-making. There's no general duty to urge or ensure any testing of another doctor, and that's in some case law.
Really what it seems to come down to is on August 8, 2018, when Nurse Walker saw the plaintiff, did he exhibit symptoms and signs of DVT? One of which is if somebody's overweight, if somebody actively smokes, there's various other things. I guess, Nurse, your argument is he smoked in the past, but he doesn't currently smoke. So that's not indicative. He was overweight, but not a lot. He wasn't obese. So each factor, there's some arguments, but I'm just not sure that's enough to take it from the jury.
So first off, I think what you're referring to there are risk factors, and that was more in Dr. Riley's brief and motion papers with the smoking and the obesity. In terms of symptoms of DVT, Ms. Walker reasoned again in her affidavit that there are clear, red flag symptoms, things that get the provider thinking that this could be a DVT. And she clearly stated that none of those symptoms were present in her examination of the plaintiff on August 8th. And again, the physiatrist in his or her affidavit didn't address that reasoning, merely in conclusory fashion stated that, swelling is rare of the whole leg, I think was the comment, without explaining how that applied to this case or
Am I mistaken? Didn't the plaintiff's excerpt make reference to the swelling, not maybe found on the examination by Walker, but in the records indicating that there had been some indication of swelling at that point?
Right. But I'm getting to the reasoning of it, how, the standard of care fits into that symptom of swelling. First off, to back up from that, swelling was a symptom of the condition of which plaintiff was referred to Ms. Walker, which was complex regional pain syndrome. So, Ms. Walker was doing an investigation of that symptom of swelling. But is
there some indication in the record that Walker was also looking at differential diagnosis?
Correct. Very clearly stated in her testimony, her affidavit, and in the office note itself.
And would DVT have fallen under that based on the swelling?
She testified that she was considering a possible vascular condition, hence the referral to the vascular surgeon. DVT is a vascular condition. However, she did list the telltale signs of DVT, which are pain on flexing the ankle, redness, which the plaintiff did not have. He didn't have that first symptom either. And palpable cords, which are actual hard areas.
What we're talking about is there may be some symptoms that were detected in the record, maybe not by Walker specifically, but in the record that were available to Walker where she would have known that. And she did do a referral to Riley, right? So
yes,
that was part of her, she was contemplating. But you're saying that it was not so strong a differential diagnosis that would have required the ordering of testing.
It was a judgment call based on the examination findings to refer the plaintiff to a vascular surgeon, as opposed to there being any symptoms which would have required an emergent referral to the emergency department.
And that's really where the difference is. That's where that lies.
And again, right? Which wasn't addressed by the.
And we have to look at the plaintiff's expert affidavit to determine whether or not that issue was addressed. If it's not addressed, then that's your point.
I believe it would be a conclusory opinion.
Counsel, can I just ask you, would you address the negligent hiring or supervision?
I did in my brief. The case law is pretty clear on that if the plaintiff is alleging vicarious liability, which the plaintiff is here, Ms. Walker was an employee of a defendant, Jefferson anesthesiologist. When that theory is being alleged in a complaint, the complainant cannot also claim negligent supervision hiring, which is a claim against an employer. And here the employer's, a party and on the hook for vicarious liability anyway.
Any further, counsel?
No, I do not have anything unless there are any questions.
No questions, counsel. Thank you.
Thank you, Your Honors.
Counsel Schoonmaker, do you want to go next?
Yes, Your Honor. Good afternoon, Your Honors. May it please the court, Corey Schoonmaker on behalf of Samaritan Medical Center. SMC's liability, supposed liability in this case would be entirely vicarious for Dr. Riley, the vascular surgeon. Thus, our motion and appeal were limited to essentially adopting the motion and appeal of Dr. Riley. Unfortunately, Dr. Riley's attorney has submitted today, so she's not available to answer any questions that pertain to Dr. Riley. If Your Honors have any questions about that portion of the care and treatment, I'm happy to answer them. Otherwise, we will rest on our papers, and I suppose.
Well, can I just ask you one quick question I would have asked Dr. Riley's lawyers is, I think, and this goes for Nurse Walker, would you acknowledge that the plaintiff had DVT on those visits, April 8th with Nurse Walker and April 22nd with Dr. Riley? I'm not saying that they should have detected it necessarily, but in hindsight, this is what he had. They were wrong, correct?
I can't say when the DVT developed. There was no, I believe there was a reference in Dr. Riley's appeal and a reference to the absence of any imaging that plotted out when the age of the clot or when it would have formed. It could have easily formed afterwards, and he may have also had the diagnosis that Dr. Riley gave him, which was slightly different. And was,
maybe he had complex regional pain syndrome. Somehow that goes away and all of a sudden he's got DVT. Because that's what he ultimately had. He had DVT.
Yes, Your Honor.
And it caused him to be 100% disabled.
The diagnosis that Dr. Riley rendered was venous valvular insufficiency. So it was a vascular condition that he was diagnosed with at the time, and Dr. Riley did agree that an ultrasound was necessary. He ordered one. The question is just whether it was in an emergent condition such that the ultrasound was urgent. And I think the key then is to look at the expert affirmation offered by plaintiff and see the ways in which it misstated what was presented to Dr. Riley and inaccurately outlined what Dr. Riley was faced with when he was making this decision as to how to diagnose this as an emergent or not an emergent condition.
I guess the answer could be they misdiagnosed and they were wrong about their diagnosis. Doesn't mean that they were negligent based on the signs and symptoms. That's a possibility here.
That
Being
is
wrong isn't
yes.
necessarily negligent.
Correct, Your Honor.
Because it seems like they were wrong.
If I'm not authorized to concede that they were wrong in this instance, Your Honor, but I can say that there are certainly circumstances where the diagnosis is incorrect, but nevertheless completely justified by the presentation. I think one of the key factors here was that when he was examined by Dr. Riley, he didn't exhibit the swelling at that time. There was intermittent swelling, and a DVT would typically result in swelling that was perceivable at the time it was occurring. So if he did have a DVT, it was throwing different symptoms than would normally be expected from it. And so any mistake would have been reasonable and within the standard of care to reach this other diagnosis that was justified by his clinical presentation.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, Charles Falditato on behalf of the plaintiff. It was about 12 to 15 minutes of questions, all related to facts. I think this is clearly a situation where should be a battle of the experts left to the jury to decide. When you use the term judgment, that's a question as to was the judgment right or was the judgment not right, and that should be left to a jury. No offense to Your Honors, that's what the law should provide for. Specifically, there are plenty of facts outlined in both the vascular expert and the pain management expert for the plaintiff that outline what the signs of DVT were, what some of them that were present at the time of these two visits, but also as to what was known about in the past that led them to both pain management, being Nurse Walker, and Dr. Riley. Specifically, leg edema, pain, swelling, temperature changes, color changes, trauma. So then you get to, well, is that enough now to do a test, an ultrasound? Well, Dr. Riley.
In an emergency situation.
And that should be left to the jury to decide. Our expert's going to say, absolutely. Here's why. There was trauma, there was this, there was that. It's been
Your
going on.
opponent says that your expert affidavit does not address that, does not demonstrate why it was an emergent situation.
I mean, it does, though, Your Honor. I think it expresses that with the reasons why, the signs of DVT, what the DVT were, the risk factors that this gentleman had for a DVT and the development of a DVT to cause exactly what happened here, which is a pulmonary embolism. A DVT starts in the leg, it breaks off, it goes to the lung. If he has a DVT, it's an emergent situation. It has to be addressed. Whether or not our expert says this needed to be done in that day or within 24 hours because of the risk associated with his condition. That's a medical question that should be left to the jury to decide. Our expert lays it bare, which is often what these summary judgment motions do, is the salutatory effect of these motions is they want us to lay everything bare in a motion. Well, we did that, and I think it laid it bare that the risk of a DVT is a pulmonary embolism, is a breaking of that clot off to go into a far worse area.
So in every circumstance, it's an emergency situation.
It should be, absolutely. And you'll hear that from, when we get to trial, that'll be exactly.
I may not be there.
Well, it's true, but that's what the expert would say at trial, given exactly what happened here, right? The risk of a life-threatening, dangerous situation. And again, our expert says why, their expert says no. The jury should believe one or the other. If this court was tasked with fact-finding, then you would have to decide. But I think that's really left to the jury to decide. And it goes to both Dr. Riley and Ms. Walker. And I'll just add with Ms. Walker, one of the questions isn't just the 8th. She did the referral. She got the referral back saying a DVT, ultrasound needs to be done for this vascular issue. Nobody ordered it. Whose job was to order it, I think, is another question of fact that needs to be decided. Neither one of them said that was their responsibility. And we know it wasn't done in the time before he developed the pulmonary embolism.
Any further?
Nope, that's it, Your Honor.
Thank you, counsel.
Thank you.
Case 130, New York State Police versus Kingsley.
Good afternoon, Your Honor.
Hello, counsel. I understand you're appearing solo on this one.
That's correct.
Please proceed.
Thank you. May it please the court, Sarah Coco for the New York State Police. The court below erred in concluding that Mr. Kingsley's participation in the fatal beating of Robert Brooks did not establish a likelihood of future dangerousness such that an ERPO should be entered.
Ms. Coco, before you dive into the merits there, can I ask you about mootness? Mr. Kingsley has since been convicted of murder second degree, among other felonies, and in late December was sentenced to 25 years to life in New York State prison. If you prevail in this appeal, you want this ERPO order to go in effect, which bans him from possessing weapons for a year. He's already, as a convicted felon, can't possess weapons. As an inmate in New York State prison for 25 to life, he can't. So why is this not academic?
Yes, Your Honor.
Why are we doing this? Because he's not going to have guns either way in all likelihood here.
So we do understand that circumstances have changed since we filed our brief in this appeal. I'd like to make 3 brief points about mootness. So the first is that the ERPO statute is designed to function independently of any criminal proceeding. So if an ERPO had been entered against him in the first instance, it wouldn't be dissolved simply because he was incarcerated. It is intended to be independent. As to practical consequences, my understanding is that Mr. Kingsley has not exhausted any appeals he might have. So there is a possibility that he would be released and the question of his access to firearms would become relevant again. So that's my first.
Counsel, on that point, let me ask you this. If that were to happen, if his appeal were to be successful within the time frame of the year, and he were to be released, if we determine this is moot, would you not have the ability to refile?
So that brings me to my second point. State police would have the ability to refile. Right now, I think the decision below would a court in the future might look at that and conclude that an ERPO wasn't necessary. So if the court does conclude that this is moot, we would ask at minimum that the court vacate the decision below, which is something this court does.
And that's as a matter of course. When we dismiss an appeal as moot, there's some thought, well, the underlying decision stays. In fact, no, it gets vacated. And if it were vacated, if we dismissed and vacated the underlying order, that would satisfy you. Because then, as Justice Whalen said, if he gets out within a year, for some reason, you could just refile.
That's correct, Your Honor. That would address some of our concerns. I'd like to make just one more point very briefly, which is that we do think that an exception to mootness applies here because this situation may reoccur. And I'm not sure if the court is aware, but there are 2 ERPOs that were denied against correctional officers that were involved in this incident. I argued the other case, Gallagher, yesterday in front of a separate panel of this court that really raises the same issues. Obviously, we hope that panel addresses the merits and addresses these issues, but we are concerned.
Well, that correction officer, he was acquitted.
That's correct, Your Honor. So there's not the same issue of
Not
mootness.
moot, yeah.
That's correct. I just wanted to ensure the court was aware of that. We do think this is reoccurring, and that's part of why we brought those appeals. That's really our concern. But I would agree if the issues are addressed in that case, and if this court vacates Supreme Court's order below, then I think that would address the concern that state police have here.
Thank you, counsel.
Thank
Anything
you.
further?
No, Your Honor. Thank you.
Thank you. Case 131, Heritage Christian Services, Inc. versus Town of Webster Board of Assessment. Counsel, proceed.
Good afternoon. I'm Ryan McCarthy from Ferrara Forenza, and we represent the Webster Central School District as the intervener respondents in this hybrid Article 7, Article 78 petition. The focus of this appeal is specifically on the claim of an exemption for real property tax or real property taxes owed by the petitioner, Heritage Christian. Section 420A of the real property tax law requires an entity to be organized for a qualifying purpose and then use the property for that exempt purpose in order to be entitled to an exemption. And before I get into the details with that, I did want to think it was important to recognize what impact this decision has on the school district, at least as one of the taxing authorities. This decision would require the district to pay over $400,000 in refunds and interest to the petitioner, and it would remove $1.5 million of taxable property from the tax rolls indefinitely. So that tax burden would then be shared by members of the community that own property and pay
That
that.
was unlawfully imposed in the first place. That doesn't seem to be a good reason.
Well, I'll get into the reason why it wasn't unlawfully imposed, but I just wanted to recognize that that was the impact of why we were here. So to that end, in addition to the requirements in 420A, this court in Jerry Holmes established that the petitioner bears the burden of proving that the primary use of the property is for that organized and qualifying exempt purpose. Now, normally a daycare center is not a qualifying exempt purpose. And just the record is abundantly clear that this is a daycare center that makes profit. There's no dispute about that question here. However, the petitioner seeks to seek an exemption from that by saying, relying on their philosophy of integration, meaning that in my words, I guess you could say it, is that the interactions between children who attend the daycare system without disabilities are encouraged to interact with children with disabilities and adult with disabilities that participate in the petitioner's adult day habilitation program.
And I'm sorry, repeat the last point you just made.
Sure. So again, this is my kind of characterization of the petitioner's argument, but their explanation for why this daycare center, which makes a profit, is entitled to an exemption is because they have this philosophy of integration where students who attend the daycare center who do not have disabilities are encouraged to interact with adults with disabilities as a part of their day habilitation program and other children who have disabilities that are also attending the daycare. The CEO of the owner submitted
Some argument as to the numbers. The numbers seem to be a lot more students attending the daycare without disabilities than students with disabilities.
Correct.
With disabilities.
At most, it was 10.6% of the students in a given year that were classified as students with disabilities. Now, there's no baseline. I don't know what that means exactly, a student with a disability. That's not defined anywhere in the law or in Ms. Geithner's affidavit. They're just claiming we treat these certain children, 10% of them at most, as students with disabilities. And they're trying to convince the court and the court below that because of these 10% of the students that attend, we should not have to pay property taxes anymore on this property and in the past and going forward. With respect to the adult,
does it matter the organization of the child care facility being under the umbrella of the disability and properly tax exempt organization?
Well, the Heritage Christian is undoubtedly organized for a charitable purpose. They do charitable work all over the place. The statute specifically requires, in the language of it, requires that the use of the property be done for that organized purpose. They're not they have other daycare centers, but that is not their primary purpose as an organization. And we would argue that even if they had some charitable intent behind integrating students with disabilities or adults with disabilities, as they're also claiming, that alone doesn't entitle them to the exemption that would fall maybe under another property that they own that is specifically organized for their exempt purpose, which was defined under the real property tax law 420A. The general term is the mental and moral improvement of men, women, and children. It's fairly broad, but that's generally where it falls under.
So let me ask you this, if it wasn't a daycare center, but instead it was a restaurant, and people adults with disability were employed in the restaurant and were engaging with patrons in the restaurant, would that be a similar argument to the daycare? Or is there a difference between those two?
I think there's a lot of factors that could go into play where it could fall out either way on that one. I think the Salvation Army case is kind of a closer analogy there. And that was relied upon by the court below, but I think it misinterpreted what that really meant, right? Because the parents of the children who send their kids to the daycare, they pay money to have their kids go here. There's no evidence in the record that they pay their money to go there because of this integration philosophy. Their website, none of the materials, none of the statements from the CEO tell the parents, or if it's not in the record at least, that we are asking your children to come here because of this laudable purpose.
Well, does the record show that one way or the other, or are you just making that assertion?
Well, it's their burden to prove that they use this the property for the purpose, right? And again, with the Salvation Army case, when we donate clothes to the Salvation Army, we know it's going for the purpose that the Salvation Army does, right? It's helping the veterans, it's giving the discounted clothes to be reused and all that stuff. There's no evidence in the record, and there's certainly nothing
But the
presented by
Salvation Army has a store and it's revenue generated.
Correct.
And it sells those clothes.
Right, and the Salvation Army case relied upon by the court below did find that was exempt, but this I think is different because that is a part of the function of the Salvation Army to collect those clothes, to employ people for that purpose, and similar to what Judge Whalen with the restaurant with people who have disabilities in that situation.
I'm just wondering how expansive does this get? If you move them from daycare, making a profit under the umbrella, what other businesses can you operate under that umbrella and make a profit if you can show some integration? I guess that's my question.
You know, the range of cases cited in the materials is kind of difficult because comparing the daycare to the Salvation of the restaurant, there's the Greater Jamaica Development Corporation, where it was undoubtedly, charitable organized entity. They operated a parking lot and they just collected the parking fees. That had nothing to do with their overall purpose or anything. It was really just a guise to make profit for the underlying agency. And they might use that money for good purposes, but as this court established in Jerry Holmes, that's not a valid reason to get an exemption under 420A.
Can I ask some procedural questions here? I'm a little confused.
Okay.
So the town is the assessing authority here. You're representing the school district and the town here? Are you appearing for the town, or where's the town in this appeal?
They did not submit their own separate appeal.
So the town, who's the assessing authority, is not appealing this. But you're appealing it, and you're bound by the town's, actually you're bound by the courts, but the town denied the exemption. And then it went to court, and the court reversed that basically and said, no, we're granting the exemption.
Correct.
But the town is elected not to appeal this. Is that where we are?
You could put it that way, yes.
And so, and your position is that this is really a factual question, it should be sent back to the, or are you looking for us to rule? Where are you today, as we say?
Yes, so I'll just establish one thing. Under real property tax law 712, the school district has the authority to intervene as a respondent, but we can kind of step in their shoes.
I understand that you have the right to intervene, but it's just unusual that
Well, I don't want to speak for the town.
In a prior life, and like you. Okay, go ahead.
But no, we are seeking to have the decision below reversed and our summary judgment motion granted which we believe established a prima facie case that there is no evidence in the record that would establish an exempt use under 420A. The court below granted the cross motion of the petitioners, and that's why we're here. So I think having it remanded back down for a factual question is an alternative form of relief. We don't believe the record supports that the petitioner can meet its burden. If there are questions of fact,
but it's a general problem, and it's a state law, which local governments hate, but that's what it is. It's 420A because the state basically, and they don't reimburse you for it.
Correct.
And they basically say if it's a charitable purpose, which can be broadly defined, and so this court said, not this court, but the court below said, yeah, we agree with the, okay, and based on this disability issue of children with disabilities, and not just the integration, but that they also service children. Isn't that correct?
Well, I mean, it's correct in characterizing the court below, but it's not correct in describing the record that was before the court. Specifically, one of the arguments relied upon that was accepted as a fact by the court below is that the petitioner has extra costs by accepting children with disabilities, but there's no basis or foundation in the record for what other daycare to do. Likewise, they argued that there's widespread denial of services to children with disabilities by other daycares, which is clearly unlawful and in violation of the ADA. And there's no evidence in the record that there's this widespread discrimination going on in preschool age daycares for children with disabilities. Yet, that's the basis that the court below used to make this decision, is that this integration philosophy is necessary to fill this need, which isn't necessarily there. And again, most of this was created, the facts alleged in here, particularly, I haven't addressed it yet, but with the profits generated from the daycare center, were all based on the uncorroborated self-serving affidavit of the CEO of the company that is asking for the refunds and is asking to not pay taxes in the future. Specifically, there was $4 million of expenses over the time that we're talking about here that are just uncategorized. We don't know where they went. They could have clarified at the motion below, oh, we pay our employees so much money, more than the average, but they didn't do that. They just left it.
A legitimate person to opine on that, but wouldn't that more lend to the argument that it should be a hearing based on that instead of just denying her because she's saying, oh, she's prejudiced because she's the CEO, but she's the person who would have that knowledge. Why is that inappropriate?
Well, it's a good point, but again, it is the petitioner's burden to show that they've used the property in accordance with the statute, which requires them not to have the pecuniary profit derived from the commercial operations. So that this isn't the Greater Jamaica Development Company case with the parking lot. They haven't shown that. They just have an uncategorized $4 million of expenses and profits on top of that have not been explained for why that qualifies under the 420A or the Jerry Holmes case. And the last thing I'll talk about too is the integration involving the adult day habilitation. Now, from the materials submitted by Ms. Geithner in her affidavit, the organization is much more focused on this adult day habilitation. They have many different residential homes and programs for adults with disabilities to assist them to interact and engage as productive members of society. The record, however, here is devoid of any real evidence that the property is actually used for that adult day habilitation purpose. They claim that 13 adults might have been there compared to hundreds of children, according to their website, that go around. It is certainly not the primary purpose. The site plan submitted in support of the motion, which was not disclosed in discovery, indicates a very small portion of the property that might be set aside. The photographic evidence of the property doesn't support that there's any separation or any specific use of the property for the adult day habilitation program. So in the same regard, it could be a question of fact to be sent down, but also I feel in our argument here is that the petitioners failed to meet their burden to show that this property is used for the exempt purpose that is organized for. Thank you.
Thank you, counsel. Counsel?
Good morning, Robert Jacobson for Heritage Christian Services. Back in the 1960s, when I went to school, special needs children would be put in a classroom among themselves. Nobody else would see them. And they'd be there from K1 until whenever. And that's bad. In fact, it's bad now. It's forbidden now. The new rule is assimilation. You have to take the kids and mix them with non-disabled children so they flourish. The same thing helps adults, but the key here is mainstreaming. That's what they call it. So you take the kids, you create a childcare, and that's what Heritage Christian does. They take care of 3,500 adults and children in New York State and 30 counties. They tried to mainstream them into society. They've got 3 child care centers, one in Henrietta, one in Greece. They're exempt. The only one that complained about it is Webster. And all they said in their denial of the exemption application is child care, not an exempt activity. Well, this is not child care. This is child care for special needs kids. You have to mix the kids with the other kids. And, you know, there's no numbers rule here. He says it's 10%. I look at the numbers. There's dozens and dozens of children that have special needs or some level of special needs. And you're not going to put them with one person without special needs. Maybe 100's the right number. Maybe it's 200. It really doesn't matter. It's not a numbers game. This property was brand new when this
It's probably a number that fluctuates pretty regularly also.
Right. And if you think about it, this facility was brand new when the case started. I think it was 2019. Then we hit COVID. COVID made it hard to do anything. Now we're out of COVID. Now it's maturing. And again, what's the right number? Is it 10-1? Is it 5-1? There's no number. It's not a numbers game. The goal is to have these kids be taken care of so they can assimilate and flourish. And by the way, it's exactly what they do in public school. In public school, they don't anymore, like when I was in school, put them in their own classroom. They mix them with the other kids. And if you need help in math, you get a pullout. If you need help in reading, you get a pullout or anything else. That's what they do here. They have classes together all day long. And if little Jimmy needs extra help, he's pulled out. That's what it is now. This is called mainstreaming. It's generally accepted. That's exactly what Marissa Geithner said in her papers. What did we get in a response? Well, you know, the opposing side didn't put in an affidavit from an expert saying, no, there's no such thing as mainstreaming. It's not important. You know why? They couldn't get one. There's not even an affidavit from the assessor or the Board of Assessment Review explaining why they denied the exemption. What the only opposition that we have, if you want to call it opposition, is the opposing counsel's affirmation, basically doing what he just did, saying why it doesn't count. If you look at the record, I have a 20-page affidavit from the CEO of Heritage Christian Services that takes care of 35 disabled adults. She's been in this field for 30 years. She not only gives her opinion, she talks about all the certifications they have. She talks about what the state of New York requires. Basically, all she had to do was explain mainstreaming. And that's all this case is about, mainstreaming. If you have mainstreaming, we're all set. As far as the revenues goes, do we have a surplus? I don't know. It's hard to say. Heritage Christian and the daycare center are one and the same. Heritage Christian owns the property. They don't charge rent to the daycare center. That could maybe take away any operating surplus. They also, Heritage Christian has people in their field, in their program, from the CEO down with expertise and special ed expertise. They provide services. They don't charge a fee for all that. So really, I don't know if there is a surplus. But you know what? When it comes to exemptions, surplus is irrelevant. It doesn't really matter. The question is, if there's a surplus, where does it go? Does it go to some guy's pocket who has nothing to do with the exemption? Or does it stay within the organization? Marissa Geithner said in her papers that the surplus stays in Heritage Christian, if there is one. Maybe it's used for all the children's programs. Maybe it's even used for the adult programs. It doesn't leave. Nobody claims that she's getting an excessive salary. The money doesn't leak out. It stays in Heritage Christian.
I was looking at the record, and it didn't seem that there was any even allegation that the money that was generated was being used in a way that would violate the statute.
Correct. It all stays in Heritage Christian. All their other activities with the adults, the 3,500 adults and children, they're all exempt. The money stays in the entity. And, they say, well, maybe we didn't tell them where the money went, or maybe the town said, well, maybe we should know more. And when I say town, I mean the school too. Well, the case went on for 7 years. They could have conducted discovery. If they didn't like the discovery, and by the way, we have hundreds of pages of discovery. They asked discovery 3 times. If they didn't like our response, why didn't they make a motion for protective order? Probably because they had all the information they needed. The key issue here is mainstreaming. And like I said.
Let me ask you about the main, and just somewhat off the point, but bear with me. Question I asked earlier, and maybe restaurant was a bad
The
example.
restaurant was the one, yeah.
I know that there's, in my experience, there was furniture business, refinishing business, where you can take your furniture and they employed disabled workers to do the refinishing. And people went there on purpose because they wanted to support this business, right? And they wanted to make sure that the business still that was doing great work and employing these nice folks continued. So where do you draw the line on what kind of business, or don't you? What kind of business allows for integration?
I would say the line is drawn as where does the money go? If the restaurant is got all these people coming in to spend money to buy food, which is an ancillary issue for
But
having.
to support the waitresses and the waiters and the cooks that are working there, and the community knows that restaurant is there and exists for that reason. Is there any reason why the restaurant couldn't do that under the umbrella?
Maybe you're thinking like Salvation Army. It's similar to Salvation Army, and they said the revenues from people buying the goods is incidental to the practice of putting these goods together and helping these people move forward in life.
You're helping the people get employment, you're helping the people engaging with the public, you're helping the public understand that these folks.
If they were special needs people, maybe. But in this case, the real question, when it comes to surplus, you can have a surplus. You can have money coming in, money going out, you can have a surplus. The question is, where does it go? Does it go to, Mr. McDonald, who runs the restaurant? Does it line his pockets? No good.
Stockholders.
Right.
Yeah.
But if it stays in the facility, it's a possible argument. But that's incidental revenue. The revenue is paid to cover the cost of the food. In this case, the revenue is primary. It's connected. The money is coming in to pay for the cost of taking care of the kids. It's a different argument. What they did in the Goodwill or in the Salvation Army cases, they go, well, the money's not really related to the people who are collecting the goods and repairing them. It's incidental, but it was close enough so they ignored it and they still gave them the exemption. In our case, the money that comes in is actually paying for the people at Heritage Christian and at the daycare center or the childcare center who are doing all the work, and they're getting reasonable salaries. And again, they could have conducted discovery over 7 years, and they could have said, well, maybe that guy's should be getting minimum wage or something like that. They never did that because it's not happening.
Yeah.
It's not happening.
Okay. Anything further, counsel?
I think I covered everything.
Thank you, counsel. Thank you.
Thank you very much.
Case 132, Long versus Stewart. Proceed, counsel.
Good afternoon, Your Honors. Greg Silverman for Plaintiff Appellant Eugene Long. There's a couple different claims in this case. I'd like to start with Long's claim that the Stivers breached their fiduciary duty to him. The key question, well, first I'll say there's three sources by which they breached their fiduciary duty. First, via joint venture. Second, as co-tenants on this lease. And third, as members of the LLC. As to joint venture, the key question here is, did the Stivers fiduciary duty to Lawn ever end? And the answer is no. The only way, if you form a partnership or a joint venture with someone, the only way your fiduciary duty in relation to the partnership assets and interests can end is either with an agreement among the parties or a court order. And it's undisputed here that that never existed. That did not happen. So, and the undisputed facts are that Mr. Stivers testified that him and my client had a business together. They would buy dilapidated properties, they'd fix them up, they sell them as a profit. Mr. Stivers testified those profits were owned 50-50, Stivers and Lawn. They then used those profits to invest in this marina campground. They maintained that marina, they improved that marina. They did that in reliance on exercising this purchase option. And
the breach of the fiduciary duty occurred when the Stivers talked to Stewart after the 5-year lease expired. I know we have an issue with 6 years of 5 years,
Yes.
but in October of 2021 and purchased it on November 1st of 2021. That was the breach, that the Stivers bought it alone without your client.
That's correct, Your Honor.
And they should, but it was clear, was it not, that both the Stivers and the plaintiff agreed that they weren't going to be owning, they were done. They were going their separate ways. Your client tried to buy it on his own too, it seemed like, right? He would go to Stewart and say, hey, I'm interested. So they were both breaching it, according to your theory, they were both breaching fiduciary duties against each other.
So I would disagree, Your Honor. First, in terms of my client attempting to purchase the property, there's emails in the record saying that my client is interested in exercising the option. He tried to talk to the Stivers about it. They wouldn't give him a clear answer. And he
knew full well it was over. Your client should out of that. They disentangled in April of 2021. That relationship was over. Your client, they were going, neither side, is fair to say, was interested in buying that property together.
Well, I think my client was interested in not losing his assets. And I think the email was that he would either exercise the option himself, or if the Stivers were not interested, he would exercise it himself, or if the Stivers would exercise it with him, he would do it that way as well. He did not want to lose his investments in the property. So he offered those two options to Mr. Stewart. In terms of disentangling themselves from...
Let me
Yes.
stop you there, only to kind of follow up on Justice Lindley's question. So you said he then went to Stewart because he didn't want to lose his assets, his investment. He didn't go to Stivers and then go to Lewis or go to Stewart together. They both went separately and individually to Stewart.
I think the key difference there is that the emails show, for the record, that my client was willing to exercise the option himself or with the Stivers. As it relates to the Stivers, they did not want to exercise the option with my client.
And remind me, the emails were sent from your client to Stewart.
Your Honor, they were sent from myself to Mr. Schiano as Stewart's counsel. And they say the Stivers won't give me a clear answer as to whether they want to exercise the option with my client. We will exercise
So there's no
it.
communication between your client and Stivers at this point.
At this point, no, right. The relationship had ruptured. And Your Honor, there is a settlement agreement because the parties had other joint properties besides this marina.
So it was not realistic to say, we're going to buy it together.
Well, I think
everybody knew, and that's why Stewart was in a bad spot, because he's basically saying, I can't sell to either one. And you guys aren't on the same page. So somebody the option expired, right? So at some point down the road, Stivers could have bought it or your client could have bought it without any breach of fiduciary duties. Is that not?
Well, here to go back to why the Stivers breached their fiduciary duties to my client. What happened about a year before the option deadline is the Stivers effectively kicked him out. They said, you're out of here. Don't come back to the property. You're off the bank account. And that was after 4 years where the parties had invested those profits that the Stivers said were split 50-50 into the marina. They paid for maintenance, they paid for improvement. And so here there was a joint venture and the parties had contributed assets to this property. And so by the Stivers going and effectively exercising the option themselves and excluding my client, what they did was they secured the assets of this venture without an account, without a court order, and without an agreement as to how they should be distributed. So in terms of a joint venture, that is how they put their interests above my clients. And again, they still, while the parties may have said, we shouldn't do business together, this relationship is over, the Stivers continued to owe fiduciary duties to my client because there was never any agreement as to how the interests of this venture were to be divvied up or a court order.
So it's not just that the Stivers purchased it unilaterally in November. It's what became of those assets, because there's only three things that could have happened there. They bought it together during the option. That's impossible. So that was off the table. It was either your client buy it unilaterally or the Stivers buy it unilaterally. One of those were the only three options. Well, there are only two options, really.
Well, so I disagree because there's testimony in the record, the Stivers, and it's in my briefs. The Stivers testified that they went, or strike that. Mr. Stewart testified that about a month before the option deadline, the Stivers come to him and they say, we're not sure we can come to an agreement with Juan. Would you be willing to sell the property to us? And he says, yes, if the terms were similar. A couple days before the option deadline, Mr. Stewart testified, the Stivers come back to him. Would you be willing to sell us the property? And Mr. Stewart again says, yes, if the terms were similar. And we know that's what happened because about a month later, Stewart sold the property only to the Stivers for the same terms as the purchase option. And so here.
So you're saying that those conversations were the breach of fiduciary responsibility, even if there was no agreement reached on the sale prior to the expiration of the lease?
Yes, the Stivers buying the property, effectively exercising the option themselves without my client, breached their fiduciary duty to Mr. Long because there was never a court order or an agreement as to how their interests at the property should be divided up in accounting of those assets. So that's the first way, joint venture. The second way is because they were co-tenants on the lease. There's authority in my brief that clearly says when you are co-tenants at a property, whether you are leasing it, whether you own this property, if you owe your co-tenant a fiduciary duty. And
what if the tenancy expires? What if the lease expires?
Well, Your Honor, there's the case of Snyder, where in that case, the parties owned the property together. One party let the property go into foreclosure. Then he bought the property at foreclosure and got rid of his co-tenant. The court said that is a breach of fiduciary duty because when you are co-tenants and you share property, if you acquire some kind of adverse title, even after your interest expires, that is a breach of your fiduciary duty. I cited the case of Menard v. Salmon, about 100 years old. In that case, two partners leased property. The owner comes to one of the partners and they enter into agreement where only one partner gets a new lease. The Court of Appeals, or the other partner sued. The Court of Appeals said the partner who got the new lease breached their fiduciary duty to the other partner because he owed a fiduciary duty because not to essentially usurp a business opportunity of the partnership, of the enterprise. And by securing this lease without the other partner, that's what he did. He usurped a business opportunity without the other one. He put his interests above his partner. That was a breach of fiduciary duty.
There was the third one you're about to get to.
Thank you, Your Honor. The third one is LLC. Both parties were members of an LLC. The Stivers said they were managers of this LLC. There was no operating agreement that allowed the Stivers to kick my client out of the LLC.
The LLC wasn't party to the lease, right?
The LLC was not a party to the lease, but the Stivers testified that the LLC was the company by which they ran their business at the marina. This was a 5-year lease. The rent was very cheap, and it incentivized them to maintain it and improve it, which they did. It's in the record about all the improvements they made to utilities and campsites and docks. And so, but the Stivers had no authority to kick my client out of the
That was
LLC.
September 21st of 2020. Your client he was no longer a member of the LLC.
Well, that's what the Stivers said. But we disagreed. There was no authority in any operating.
Right, so, but,
Yes.
okay, well, at some point, he was no longer a member of the LLC, your client.
Disagree, Your Honor.
Well, you're saying he was unlawfully removed.
Correct.
Okay.
Yes.
And why they didn't follow the articles of incorporation or why was he illegally removed?
Well, there was no operating agreement. And I cited case law in the briefs that said without authority in an operating agreement, one member cannot just kick another member out. And there's also case law that says fiduciary duties extend to any matter relating to the fiduciary relationship. And here, the Stivers testified, the LLC was the company we ran the business at the marina in reliance on eventually exercising this option. What the Stivers did was say, yes, we will take the partnership assets and the money and invest it in the marina. And then a year before the option deadline, we're going to kick you out and we're just going to take it ourselves. And you have no recourse. And that is not the law. The Stivers had a fiduciary duty as joint ventures who, without any type of accounting, to divvy up partnership assets and formally dissolve their venture as co-tenants and as LLC members.
Yeah, the argument that's tougher for me is with respect to Stewart.
Yes, and yes, I have to get that.
Stewart's in a tight spot there. The agreement says sell to both. That's not possible. What do you want him to do?
Well, so Your Honor, I would disagree that that's not possible. There's testimony in the record where the Stivers said at the end, when they didn't want to come to an agreement with law and they were, quote, scrambling to save their assets. They were concerned that Stivers would walk away with, quote, the whole kit and caboodle. And so what they did is they went to Stivers and said, will you sell to us? Or sorry, the Stivers went to Stewart and said, will you sell to us? Now, just to clarify, we have a claim of breach of fiduciary duty against the Stivers only. As to Mr. Stewart, we have a claim, well, only to him of breach of good faith and fair duty, because in this case, he was the lessor. He was the optionor in this lease. He had the option, and the condition precedent to exercising the option was Lawn and Stivers get together and they give him joint notice that they want to exercise the option together. Now,
so if neither one, he just should have, what if he sold it to a third party?
If Stewart did?
Yeah, any problem there?
Well, I think if Stewart sold to a third party, and the Stivers and Lawn didn't decide to exercise the option together, I think he'd probably be fine. My client wouldn't have a claim against him, but what happened is he told the Stivers that he would be willing to sell it to him. He interfered. The trial court said the standard for breach of good faith, fair dealing in this situation where there is an option is we had to prove that he agreed to sell the property to the Stivers before the option deadline. Now, I think he did, but that's not the standard. Yes, sir.
Yeah, what you're saying, I think what I'm hearing you say is the Stivers went to Stewart before the expiration because they were concerned about losing their assets and he might sell to a third party. And then he got their assurance that once it expired, that he would sell it to them. That's the problem that you're having with this in terms of fiduciary responsibility and
good fair dealing. Correct, Your Honor. As specifically to Mr. Stewart. Now, Mr. Stewart could have said, instead of saying to the Stivers, yes, I'll agree to sell it to you. We just got to wait till after the option deadline. That's in his deposition testimony. What he could have done is says, I'm out. You guys got to figure it out, or I'm out of here. Now, in that situation, Your Honor, I think the parties would have exercised the option together to secure their assets because they had invested so much. And they, like Mr. Stivers testified, they didn't want to lose the whole kit and caboodle.
So Stewart could have said, come to me on October 17th, 2021, and we'll talk.
If you and Lon can't figure it out, come to me and we'll try and figure it out.
And then I'll consider selling to you or him individually after the lease expires.
Exactly.
And that's not a problem.
Exactly, but that's not what happened. He said, I will sell to you on the same terms as the option. It's got to wait till after the deadline. And we know that's exactly what happened. So in that situation, the standard is not whether there was some binding contract between Stewart and the Stivers. It's whether Stewart prevented, hindered, or frustrated the Stivers and Stewart coming together to exercise this option together. And so clearly, Stewart interfered with. He made it substantially less likely that the parties would agree to exercise this option together to at least secure their assets. And if they had done that, then they could have said, well, look, let's exercise it together. Let's secure our assets. We'll figure this out afterward. Let's not let Stewart get 4 years plus of our money that's being invested in this marina. So that is why.
Your time.
Oh,
You should wrap up.
Thank you, Your Honor. I just will say, we'll rest on our brief. Thank you very much.
Thank you, counsel.
Good afternoon, Your Honors. It's always difficult at the end of a long day. I'd like to begin where counsel left off. And I think that's been the problem with this case for a while now. I think the statement that counsel made was that Mr. Stewart told Mr. Stivers, would he sell it, when he asked him, would you sell it to us in the future? Counsel's words were, yes, if the terms were similar. That does not exist in the testimony. Mr. Stivers' testimony was, and the question by counsel was, and what did you say? Mr. Stivers responded, and Mr. Stewart responded, and I said, it would depend. It would depend on if the terms were similar or whatever. It was completely non-committal. All he indicated was maybe. Well, it depends on what the terms are.
Language is a funny thing. It would depend on if the offer was similar, or the terms were similar, and if the next line is, and if they're similar, then yes. I mean, the assumption there, is it depend on other things, or is it just depend on that? We'll look at the language of that.
You are correct, Your Honor, but the question was asked again of Mr. Stewart, and his testimony was, quote, and I said it would depend on what we could work out. And then he adds, that would have to wait until after. And so there was no commitment, there was no misrepresentation or breach of fiduciary duty with regard to Mr. Lawn.
Can I do this? The Stivers, you represent the Stivers.
Yes.
And they bought this marina that Mr. Lawn had been contributing to, and while he managed it and brought value to it. But for this breach of fiduciary cause of action, is not Lawn entitled to some of that increased value in some other theory? Or it would seem, or does the value that Lawn can get out of this former joint venture contingent only on this breach of fiduciary cause of action?
I think it's probably importantly contingent on that, Your Honor, but it's important to note here that when the parties invested in the property, they didn't leave the investment in the property. They took their money back out. And when the relationship ended, the Stivers did an accounting. They determined that there was no capital contribution left because almost as quickly as money was put in, was also taken out.
So Lawn's already been paid for his.
But he still has available to him a claim under an accounting to see if that accounting was in fact correct, which is still pending before the court. But what we really have happening here is that the plaintiff is indicating that there's some duty by way of a joint venture. It's clear that the joint venture was terminated. If it ever existed, it was an at-will joint venture, which by rule can be terminated at any time. In the instant case, the parties were unequivocal. We have letters from.
Are there documents in the, sorry to interrupt your argument, are there documents in the record that clearly indicate that it was terminated and it's in writing and it's from the Stivers to Lawn? We hereby terminate effective this date. Words to that effect?
That's an excellent question.
Or is it in a more informal, we're not getting along anymore, you've got to leave.
So the law is that it can be terminated by word or actions, and here the parties had a rupture, terminated his employment from the other marina, terminated the relationship, were no longer speaking to one another. And as a result of that, situation, plaintiff's counsel sent a letter in writing to Mr. Stivers saying, I represent Mr. Lawn. He regrets the breakdown of your business relationship. He believes that it's best for the parties to disentangle any of their ownership together. That was in April of 21. Then after the lease expired at the end of the day on October 14th, and before the Stivers bought it on November 1st, the parties signed a settlement agreement with regard to the other pieces of property that they owned at that time. One of the recitals in the agreement that they both signed, that was drafted by plaintiff's counsel, said, whereas the parties don't want to own any property together. So it's clear that the parties, both in writing and through their actions, said, this relationship is over. We don't want to own any property together.
What do you say about the argument on the breach of fiduciary duty for the LLC in September 2020 that they unilaterally threw out Mr. Lawn, and that was not pursuant to the proper legal channels?
So under LLC law, absent an operating agreement, it is the ownership of the LLC that controls the business of the LLC. At that point in time, Mr. Lawn had nothing, maybe a fractional 0.5% share of the LLC. So Mr. Stivers and Mrs. Stivers had functional control under LLC law because the parties never agreed to an operating agreement. This entity, this LLC, had no ownership interest in the lease or the option. It had never received an assignment. It had nothing to do with that. That resided solely with the individuals. The individuals here made clear from the outset that, look, we may exercise this option together. There's no obligation to exercise it. Essentially, each one of them had veto power. If they got along, great, they would buy it. If not, they all knew and all took the risk from the very outset.
At a point in time, though, counsel, I'm just assuming there came a point in time during the 5-year lease where these are annual renewable leases, right? And I know there's a discussion about, is it 5 or 6, but there had to come a point in time where the parties had put so much into this business and improved, because the papers indicate that what they took over was in pretty poor repair, right? And so this was a joint effort to improve this property and make it worth something, right? And so they were putting this money in to improve the property. There had to come a point in time where one or both of the parties knew, and I think there was even part of the argument discussion earlier, that we have too much here at stake to let this lapse and allow the owner to simply either lease it out or sell it to somebody else.
That's a great question, Your Honor. Let me give you my response to that. So when the parties invested money into the marina, again, they took it out. Principally, Lawn took out his money quickly. What Mr. Stivers and Mrs. Stivers left into the marina was contributions from their other marina. So when they put in pylons or docks, they used their equipment, they used their employees, they used their materials. So the investment in the marina, other than what they put in by way of cash and then took out, was really all of the Stivers. Even with that, the Stivers thought and let the lease lapse. They let it run. They did not invoke the option. It expired at the end of the day on October 14th because they preferred to take that chance that they could buy it afterwards. So they took a calculated risk. They could have lost the whole thing. Mr. Stewart could have said, yeah, I'll sell it to you, but the price is now twice as much. That was certainly within his rights.
Lawn could have bid more.
And here's the reason why Lawn didn't even bid more, and why, in fact, he really didn't want the Stivers to exercise the option. He misconstrued the option. So he gave notice to Mr. Sciano and Stewart by virtue of that I will exercise the option alone or with the Stivers. So he thought he had it buttoned up. He thought the worst he could do was, if the Stivers bought it with him, great. But if they don't, I get to buy it myself because I invoked it. So he didn't really care or want the Stivers to buy it, right? Because he thought he had it buttoned up. When the Stivers bought it after the lease and option had expired, he brought suit. And his second cause of action says, Stewart was obligated to sell it to me because I invoked the option alone. He misunderstood the option. In reality, that's why he was willing to take the risk, because he thought he had triggered the option. But in fact, he didn't. And it is law of this case in both.
That's your take. That's not really in the record.
That is not in the record. That is me looking at the pieces. But to answer your question, did there come a point where they worried about this? I can tell you that Stivers certainly did. That was their concern. They were willing to take that chance. And I believe Mr. Lawn took his calculated risk based on how he interpreted the option.
Okay. Anything further, counsel?
Your Honor, there were a couple of other issues raised, unless the court has anything. I know it's the end of a very long day.
No, we're good.
All right. Thank you, Your Honor.
It pleases the court, Cristiano, attorney for Mr. Stewart, defendant, respondent. I've been listening to the responses from the court, the questions and the statements being posed. I'd have to agree with Judge Lindley on this. We were in a catch-22. Nowhere to go. The option was over. He keeps talking about option. The option was over. And the language saying that he was going to sell just to the Stivers, I believe his testimony was, we'll see what happens when the option's over. So there was no guarantee. He could have kept the property himself. He could have sold it to a third party, as stated. They had to buy it together. One of the reasons why, he was holding paper. It was going to be a mortgage. And if you were a bank, you're going to give it to the person most reliable to hold the paper, right? So
He also probably didn't want to be involved in any kind of litigation. How'd that turn out?
I told him that too. So he could have kept it, and kicked them both out. I agree with the court on that. After listening to the court, I'm assuming that most of my arguments are covered in regards to my brief in regards to the 5 and 6 years. So I'd rest on my papers and the request made in that, unless the court has any other questions for me.
No questions, counsel. Thank you.
Judge, thank you. Good signal.